Hey, what's up? So, surprise, surprise. I'm going live again. I went live last night and I'm trying to go live with y'all more when I have stuff to talk about. And so, the US versus Skrmetti case, they did their oral arguments yesterday and they have posted the full thing. And it's about 2.5 hours long. And so, if you know me and my lives usually go for like 3 to 4 hours, So I thought that was light work for us to do. You feel what I'm saying? So I want to listen to the oral arguments and we can stop and pause and discuss if we need to discuss. If you don't know what the US versus Skrmetti case is, let me give you a little rundown. So the United States versus Skrmetti oral arguments case is the Supreme Court. The case has gotten to the Supreme Court to where Tennessee has banned transgender medical treatment for minors. And they say it violates the Equal Protection Clause of the 14th Amendment. Tennessee enacted its law in March of 2023, which stated that there was a compelling interest to protect minors from the physical and emotional harm by banning healthcare provided from administering hormones and puberty blockers and surgeries to minors for transgender purposes. Transgender minors and their families sue the state, and the Justice Department intervened on their behalf, arguing that the law discriminates on the basis of sex. A district court, the district court then stopped the ban on hormones and puberty blockers, but the Sixth Court of Appeal reversed that decision, and the Justice Department that appealed to the Supreme Court. Chase Strangio, I love Chase because Chase is like the Ruth Bader Ginsburg, Thurgood Marshall, Polly Murray of our time, of our particular community, because they are a lawyer, an amazing lawyer, and trans. And so them being one of the lawyers on this case is not only groundbreaking, but also, you know, they're one of us. It's not just a cisgender person fighting for our rights on the Supreme Court level. It's actually a trans person who have experienced being trans and who has invested interest in winning this case. This case is personal to them, and you can tell by their work and their dedication to it for many, many years. Even they were involved with a case back in 2020 when we were trying to get the right to not be to be included in the 1964 Supreme Court Act, where is it 64 or 68? I can't remember. I don't remember. Somewhere in the 60s when we got the right to not be discriminated against based on sex, religion, blah 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 blah. We were included as trans people, included in that Title 9, Title 7. I got so many titles in my brain. I'm lawed out. I ain't even a lawyer, but lawed out. I can't remember the exact title, Title 9 or Title 7, title something. We were included in that in June 8th of 2020. So look that up. They also were part of that case. So this is a person who has dedicated their career to advancing trans rights, and they are one of the lead lawyers at ACLU, American Civil Liberties Union, who is also the org that helped me win my case. So I have a special place in my heart for ACLU, even though, there's some problematic stuff in the past. But ACLU is just one of the people that wants to protect the rights. So sometimes they're going to be on the bad people's side. Sometimes they're going to be on the good people's side. That's just how it works when you like protecting the rights of people. So anyway, Chase Strangio is the person who argued on behalf of the trans minor and their parents, and literally is the first openly trans lawyer to argue before the court. And so I'm really, really proud of Chase. And so I thought that it would be cool if we listen to the oral arguments together and have fun with it, because I know listening to legal oral arguments can be kind of boring. But if we're talking about it together, I mean, wouldn't it be dope to be fun and discuss it in the middle of the process? So y'all want to go on the ride with me? Let me see who is here. So yes, that is the US versus Skrmetti. We're gonna listen to it. I'm gonna see if it plays, and y'all can tell me if y'all can hear it. If not, I'm gonna switch it to my phone, so y'all can hear it on my phone. But if y'all can hear it on the computer, then that'd be even better. And y'all tell me what y'all can hear. But before we start, let me say hey to everybody. Hey Darcel, how are you? Raven, Ricky, hey Ricky, hey Trishawn, hey CL, hey Aston, hey Fresh. How are y'all doing? It's kind of hot in here. Let me take this army jacket off. It was cold outside. Hey Brianna. Brianna, was you in there listening to them go off? I already listened to it, and I got my life when the way Katanji Brown was fucking dragging it. I got my whole life. She kept on bringing up Loving versus Virginia. I was getting my life. I was outside freezing my ass off. Oh, it does. It was giving cold in your pictures. I was like, oh, I thought y'all was in there. I didn't know y'all wasn't in there. I have my snacks. I have my red Thai tea. Almost gone. Heckling the counter protesters. Girl, counter protesters. That is crazy. And then they're the queer counter protesters. Like, y'all queer. It just feels like they're gonna come after you next. Like, that, right? Not even next. They're coming after you now. Let me take that back. Not next. They're coming after you now. There literally is a rise of non-trans related legislation against LGBT people, minus the T, LGB people. They're literally coming after you now. And this whole privacy and this whole thing that they're trying to uproot definitely uproots Lawrence versus Texas. So your ass definitely gonna get wore out too, right? So anyway, that's a whole subject. So I have some cute little snacks for now. I have, do y'all know what Turkish delights are? We have a Palestinian bakery and shop here. And they sell different varieties of Turkish delights. And I went and got some. You have these are rose petal and pomegranate and pistachio little bars. And these are, I don't know what they are. I just tried them and they were delicious, but I don't know what this shit's made out of. But I know these are rose petals and pistachios and pomegranate. And they're fucking dope. So good. So delicious. There's that. So those are my snacks for today. And then we have these. These are also Turkish delights. But these are rose. Like these rose little gelatin squares. Now these are more like, those are more like candy bars. These are more like soft, chewy, really soft, chewy candy. Love them. And they don't make their stuff with a lot of sugar, so they're not like extremely sweet. Yes. Hey, Ty. Is it like mocha? No, it's not like mocha. I don't really like stuff with like coffee and shit like that. I really don't like chocolate like that either. I'll taste chocolate, but that's not my favorite. My favorite kind of flavors are sour. I like sour apple, sour, anything that giving you Sour Patch Kids, sour straws. I love that. That's my favorite kind of candy. But another one is things that are I like peanut butter and chocolate together. but things that are like creamy and fruity. Like anything like milk and fruit based, I really like it. Um, the squishy moochie. Oh, I don't even know what that is. It's kind of like moochie as far as texture to me. Yeah, I don't even know what moochie is to even compare. All right. All right. So let's go. Let's swear it out. Let's sit and listen and see what the tea is. We have US versus Skrmetti oral arguments, and it's gonna start now. Y'all tell me if y'all can hear it. I hear that? Skrmetti. Can y'all hear it? Can y'all hear that music? Before I skip this commercial, it messed up your audio. All right. Yeah, so I'm gonna have to put it on my phone. All right. All right. So I'm gonna have to put it on my phone so that y'all can hear me. All right. Let me get my phone out. But y'all can hear me. Y'all can hear me now. All right. So I'm gonna put it on my phone so that we can listen to it on the phone and the thing will be separate. I don't know what was going on with the conversation yesterday though. But yeah, I was loving that conversation because baby, them numbers, they're going green. I guess I like when we talk about messy shit like getting clocked. Ah. All right, let me. We are a messy bunch. Ah. My friend be telling me you need to be more messy, but I don't like being messy. Not messy like that. I like being messy how we was yesterday, but I be knowing tea about people, and she feels like I should be like Wendy Williams, and I'm like, no, because then that's what's going to be expected of me, and that's not my natural personality. And I don't want to be that person. Um,
Just announced, Walmart, Target, CVS, and Walgreens are now accepting the grocery allowance card.
can y'all hear this?
The Supreme Court heard oral argument in a case challenging Tennessee's ban on transgender medical treatments for minors and whether it violates the Equal Protection Clause of the 14th Amendment. This is about 2.5 hours.
We'll hear argument this morning in case 23477, United States versus Skrmetti. General Prelogger.
Mr. Chief Justice, and may it please the court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria. But SB1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as.
This person who you are listening to is on our side. It is Elizabeth Prelogar, Prelogar.
A gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients. SB1 categorically bans treatment when and only when it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB1 should be upheld so long as it's not wholly irrational. That's wrong. SB1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care, but here Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB1 can be reviewed under the correct standard. I welcome the court's questions.
All right. So she's laying out the problem. And so what does it mean to appreciate your sex? I'm sorry. I'm slow and I don't know much about this. You're not slow. That is a great question because that is one of the questions that later is debated and asked in this oral argument. Because Tennessee is said to me, I am not a lawyer. Let me make that very clear. I'm not a lawyer, so I'm not going to be an expert on exactly how all the law works. We do have a lawyer in the chat, and they might can jump in, not obligated to, of course, but they might can jump in. But we are learning together. But I'm going to tell you what I know, and we're learning together. This is not something to think that if you don't know about it, that you stupid or you slow, da, 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 da. Don't even think like that. We are all learning. And this is on the cusp of change in our country. So we are all in this process of pushing our culture forward towards the protection of trans people, or if the decision is bad, against trans people. But it doesn't mean it ends. It just means we got to continue to fight to push. Just like they roll back Roe versus Wade, we could even if we lose this one years down the line, we might be able to roll that motherfucker back too. So this is just how the project of democracy works. Sometimes kind of think about like Dred Scott. That was a horrible decision. Dred Scott was a horrible decision for Black people. But eventually, we turned it back. And so that's just what's happening when sometimes you win some, you lose some. Sometimes in the moment, it's not, we haven't done the work to convince people on our side. And then sometimes we have. We are at the precipice of one of those moments where we are trying to convince people of trans people's humanity, of our right to exist, of our right to the autonomy of our own bodies, the autonomy to make decisions about our own bodies, even if somebody else, the majority of the nation, because this is a democracy, even if the majority of the nation thinks that we should not have that right. Because that's another thing that comes up later, where because we are 1%, does the majority get to tell us what we can do and not do with our body? And then so and so. So don't think that you're slow. Don't think that if you don't know every detail about this. You're not a fucking lawyer. You're not slow. And sometimes we're not even paying attention to certain cases. So don't think that. Anyway, what they mean by appreciating your sex in this context, right-wing conservative people want you to, they want to stop trans people from existing. They want to stop trans people from being able to take medications to change their sex, to live their affirmed gender, to change their physical attribute to be aligned with the gender that is affirming. This goes against the standard of care for trans people that has been going on for many of years. And so because there is a spotlight on trans people, they are attacking us now in a way that they did not, because we were in a subculture of a subculture. We were the subculture of the LGBT, the gay LGB by themselves. We were even lower than them. So now that we have the spotlight, now they're coming up with strategies to be against us. And so this is the battlefield. This is where we battle on the legal grounds of that stuff. And so when they say they want you to appreciate your sex, because they are trying to stop trans youth from being supported by their parents and getting the health care that they need, what they're using is the law to say that we need to protect the children from this kind of ideology. And we want to force them in a situation, even if their parents want to support them in a way that aligns with the medical field. They want to enforce the gender binaries and force children to be in a situation to where no matter if they're trans or not, they have to appreciate their sex from birth, totally ignoring their state as being a trans person. You feel what I'm saying? So they want them to, you need to appreciate being born a female. You need to appreciate being born a male. And so you shouldn't be allowed to take medication. It's forcing you to be the gender that you were born, which is the antithesis of what trans people fight for. Got it? That's my interpretation of what is happening. Like I said, I am not a lawyer. I am not I'm an expert on trans shit. But legally, this is what it sounds like they are doing. Got it? All right. So let's listen. So now they start asking questions.
The latter part of your opening statement,
Clarence Thomas
suggests that it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's really for minors. So why isn't this simply a case of age classification when it comes to these treatments, as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making that this isn't a sex-based line in the first place would equally apply in that context. But the court has likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how the state ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference if a girl takes testosterone or if a boy takes testosterone?
So the district
He sounds like a queen to me, like an old queen.
In detail, and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with the cross-sex use of the hormones.
Is there no physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth sex of who
Well,
is taking
I'm
those
more
medications.
interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to in a female, and
So,
vice versa for estrogen.
So if you take hormones, they will prompt the development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth. And in fact, that's one of the intended effects of these treatments, because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks, and that it leaves regulation of medication unrestricted, even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just... Counsel, you rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig v. Bourne and some of the other ones where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset. And it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally, that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certain prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig v. Bourne, different drinking ages, or Morales, can men and women adopt children in the same way?
And I think the court could recognize that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there's some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think think we're asking the court to break new ground in this case. And in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification. But then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
General, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote: overwhelming evidence establishes that
this is Lido.
Gender-affirming treatment with puberty blockers and hormones directly.
All right. It's two things I want to talk about while we are here before we keep going. I'm going to post a link of the current justices, just to give you a general idea of the current justices. All right. So Justice John Roberts, he was appointed by Bush. Justice Clarence Thomas, he was appointed by, who was Bush appointed by? George Bush as well. Both of these are George W. Bush appointees, except Clarence Thomas is the daddy Bush, George Bush, the first one, not W, not the son. Stephen Byers, appointed by Clinton. Samuel A. Alito, appointed by George W. Bush. Sonia Sotomayor, appointed by Obama. Yes. Elena Kagan, I think that's how you say her name, appointed by Obama. Brett Kavanaugh, appointed by Trump. Amy Coney Barrett, appointed by Trump. And Ketanji Brown, appointed by Biden. I think that's all that's left currently. All right, I think that's all, right? I love that she is speaking with common sense for something that should be common sense. Absolutely. Another area that I need to talk about. So they keep talking about, now remember, I am not a lawyer, so make sure y'all doing y'all Googles and doing y'all things. So I'm just conveying what I know about what we're talking about. Okay. So I want to make that very clear. So this is not my expertise, but Bush Sr., yes, appointed Clarence Thomas. So yes. So she keeps mentioning heightened scrutiny. Okay. So heightened scrutiny is a more like demanding form of judicial review that is applied in certain circumstances, such as when like a fundamental right is implicated or there's a specific classification of something. In these cases, usually the government kind of must demonstrate that the law is substantially related to achieving important objectives. Okay. So she keeps mentioning heightened scrutiny, but there is like a intermediate scrutiny, which is kind of like a low level scrutiny. But heightened scrutiny is kind of a lower level, not intermediate, because that's heightened scrutiny too. But there's a lower level of scrutiny. But when you want a heightened scrutiny, it's like a more rigorous or like a rational based test and less rigorous. Like you really need to pay attention to this because this is big. This goes up against like constitutional shit that we've already argued. That's what it feels like to me. So the Supreme Court uses different levels of scrutiny depending on the nature or the issue of what they're kind of going up against. So for example, the First Amendment cases, there's a strict scrutiny and has the most demanding standard because that's the First Amendment. Like you have to be able to kind of prove like a compelling interest in like the least restrictive way. Kind of like you gotta you got like this is just the level. This just means this is about that life. This is about that serious shit. This ain't something that's like you gotta play with. That's what it feels like to me. Like this is um it just means that this is serious. Like you gotta judge this with like heavy scrutiny, baby, heightened scrutiny. So I hope that makes sense. This ain't no bullshit. This is coming up against our constitution, honey. And you need to pay attention. All right. So yes. I don't fuck with the New York Times, so I'm not sharing that. Especially, and this when I'm talking about heightened scrutiny, this is when we are challenging laws and making amendments and stuff like that. So here is challenging laws, 3 levels of scrutiny. Yes. Yes, yes, yes. Brianna's giving us good education, strict, intermediate, and rational basis. Yes, 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 yes. She's the law. She's the Esquire, baby. So she knows the Black trans Esquire. All right. So we're gonna continue. So that's what we're talking about. I hate that my phone keeps fucking.
And substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the CAS report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the CAS report and Sweden, but neither of those
can be medically necessary for some minors, but for the general run of minors, do you dispute the proposition, in fact, that in almost all instances, the judgment at the present time of the health authorities in the United Kingdom and Sweden is that the risks and dangers greatly outweigh the benefits? Do you dispute that?
I do dispute that, because if you actually look at how those jurisdictions are addressing this issue, they have not outright banned this care. The CAS report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course, it's true that they have called for a more individualized approach to these issues and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that in England, I'm sorry to interrupt, but the time is running out, that the National Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and are already on estrogen, but for those who are under the age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the CAS implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Is all of that true?
I believe that all of that's true. It's outside the record in this case. And so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel.
All right, so I want to start right there. So what they are doing, somebody who is opposed, or conservative, I'm going to say opposed, but conservative. They are looking at, what he's calling out is that there have been studies done for many, many decades, because we as trans people know that we have been around for many, many decades. And there has been studies done, there has been work, there has been many of psychiatry, psychologists, and who has done work around our lives, around our treatment, around our care. And so there were cases that worked in our favor, okay? But because of the anti-trans rhetoric and the anti-trans conservative push that's happening globally, there has been people who have put out research, a lot of times paid people, to literally paid by right-wing think tanks like the Heritage Foundation, paid by just so they can have something to stand on. Because if they go by the legitimate stuff, they won't win. So they had to pay a lot of doctors to have anti-trans stands, in the same way that they pay scientists to have anti-climate change stands, even though respected scientists have all told us that this global warming and climate change shit is real. But when they are working against, when the conservative folks are working against doing the work that it takes to minimize pollution, minimize all the environmental stuff, they will get scientists, pay them to say something against what is actually the truth. Okay. And so in recent years, we have seen a lot of that. So what the judge keep bringing up is these like new versions of these studies in Sweden, in Finland, in the UK, that have been pushing anti-trans narratives. And do you see what I'm saying? So if he wouldn't even have this kind of argument if we wouldn't have had this 10 years of pushing this narrative, almost 10 years of anti-transness. So even bringing up some of these studies, somebody who examined these studies really, really well, who I love, is Javon Bradley. I'm going to he is a YouTuber, cisgender guy. He does debates with right wing or conservative people, and he does a lot of the trans debates. And he really breaks a lot of the stuff down because he has dived deep into the studies, and you can always tell when people have not. So I wanted to kind of call that out. And also call out that how a lot of our shit is rooted in white supremacist European knowledge because of colonization, and because we are, in a way, because we are a new country, we have disconnected ourselves from European, but for many, many years now. But that is still grandfather oppression, granddaddy oppression. Okay. The UK, even if you know anybody who has went after their PhD in this country, a lot of times, especially if you're doing some new shit that has never been explored, in order for you to get your PhD, you have to connect your dissertation, your work, your field of study to some old white man's work in order to be legitimized in academia. And a lot of times, if you're doing something brand new that nobody has ever explored, you still have to find the connection with some old white man's work that probably happened in the 1800s in the UK or blah, 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 blah. It is always that forced connection of European academia, European laws, European da 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 da, and totally ignoring any kind of nuances or new frontier that we exploring. Maybe my work, because it's so groundbreaking, does not need to be attached to some old white man's work to legitimize it. It could be legit. I remember my friend, their work was around medication. They have a degree, a master's degree, and they went to Spelman. They're a trans person. They've been on the show. It's Arandrian. They have, if I'm to understand, they have a master degree around like diseases and stuff. They worked at the Center for Disease and whatever. I can't remember. What's the CDC letter stand for? Anyway, they worked for them for so many years. And when they were trying to go for their PhD, they had a particular narrative that they were trying to study, and it was about Black women in the South, and a really specific groundbreaking study that they were trying to do. Thank you. Z from Atlanta. Yes, they're not from Atlanta. They're from New Orleans, but they lived in Atlanta at the time. So one of the things that was frustrating for them when they were going after their PhD is that they had to connect their work to some old person's work, some old white man's work. And they dropped out of their PhD program because of that exact reason. Because I shouldn't have to connect my work to somebody else's that has no relevance. Yes. So I think it's a nuanced conversation, but I also think that we got to make these connections. You see how they are bringing up studies that are done in Europe as almost like a standard to follow. And the lawyer on our side is like, yeah, you might can make that distinction, but they still haven't dismantled those laws. So we have to be careful that they didn't stop the care. All right. So I wanted to just say that.
Justice Thomas, anything further? Justice Alito? In your opening brief, you did not mention any of these European developments, and in your reply brief, is it not true that you just relegated the Cass report to a footnote?
So, Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically ban it no matter the need. With respect to the Cass report, that isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary Cass was not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief, that's obviously a facial sex classification, but our primary argument is SB1 is worded exactly the same way, and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language in a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment. And the court has addressed the question how an equal protection claim should be analyzed when the law in question treats a medical condition or procedure differently based on a characteristic associated with just one sex.
Brianna, explain what do they mean by box stock argument? Is that a particular case? What is they talking about? Is it, how do you spell that so I can look it up? I assume that box stock is a case. How do you spell that? Yeah, I assume it's a case. I just don't. How do you spell that word, that name of that case? What's the history of that case? Bostock. All right, so let's look that up. Bostock versus Clayton. Oh, I see. Here is okay. I know this case. Okay, that makes sense. I thought it was a different word. Bostock. I know this case as Clayton. I didn't know that the first part. I didn't know the first part. All right, so yes, perfect. Box stock. Bam. Let's continue. Brianna, why are you calling me? You know I'm using my phone to play this stuff.
That was Godaldig in 1974, reaffirmed in Dobbs in 2022. Oh. And neither Bostock nor Dobbs saw any connection between the Bostock reasoning and the Godaldig-Dobbs standard. Bostock did not mention Godaldig, and Dobbs did not mention Bostock. So why should we look to this Bostock type reasoning here?
So, with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the court's approach in Bostock and what this court has long done under the Equal Protection Clause. In both contexts, the court has made clear that the right to equal treatment is an individual right. So, you look at the particular person and see how the law affects them. And the court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So, for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose the statute said, let's just talk about puberty blockers. Suppose the statute said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty, so it's ruling out precocious puberty?
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex. And we're doing that because we have an interest in having minors appreciate their sex and not be disdainful.
Well, let me ask
sex.
one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs. And yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex. And that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through,
right.
And I don't think it's controlled by Dobbs or Godoldig.
Thank you, General. Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course, we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think that's an important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
with respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether. The Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected in the laws of those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, the things that are wrong or right. For decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide.
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
Come on, Sonia!
One of the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compelling. necessary.
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
Justice Kagan?
All right. We following so far. Come on, Elizabeth, word out. So right there, Justice Sotomayor comes in and gives more context to those cases that Alito, was it Alito or Roberts? I can't remember which one it was. One of them hunkies. Hunkies with a peen. Justice Sotomayor comes in and give more context, even in that research. In those cases, they say that stopping the care could be harmful. Like, they literally is talking about, like, no, we're not saying that the care is not important. You just got to base it on an individual basis. But what Elizabeth is saying is like, yes, we're not telling you to navigate this in a way where there's some nuance to it. Cool, be nuanced, but that's not what Tennessee is doing. Tennessee is saying, nah, bruh, none, ban, stop, period. No, under no circumstances, don't give gender affirming care to minors, period. No, nothing. No kind of nuance, no kind of exemptions, similar to abortion, where here in Texas, is like, under no circumstances, no abortions. Abortion ban in many of the, not many, but a lot of states have got just abortion bans done, because when they undid Dobbs, overturned Dobbs, it pushed the decision back to the states. Instead of being a federal protection, it pushed it back to the states. And so there are some states that are like, boom, immediately it's a ban on abortion. Instead of having nuances like, what if there's a medical condition that's why we see women dying when they are having these stillbirths or these miscarriages, and the doctors aren't willing to help them get the baby out of them, and it's not coming out. And then, damn, I got sepsis, and now I'm about to fucking die, and the doctors is not even fucking helping me because there's an abortion ban. And damn, I'm dead and now I can't even, and some of them already have children. So now my children, even though y'all think y'all care about children, now my living children don't have a mother no more, because you didn't allow the doctors to step in and save me, because you're not giving any kind of nuance. You're not giving any kind of leeway for certain circumstances to be able to help me live. Failing me as a mother, failing me as a woman, failing me as somebody who needs critical care. You're not allowing any kind of nuance for that to happen to help me. So I die. Crazy, insane. So I'm sitting here I'm in an emergency, and you're sending me home because the doctor is saying I can't do nothing, or they might lock me up. I know what I can do to help, but it will be considered an abortion. But I can't, because I work in a fucking state that tells me if I help them do this, I can be criminally liable. So or I get my license taken away. So it not only is it affecting my livelihood, it can either ruin my career or send me to jail. Because you don't want to give any kind of nuance. And so what Elizabeth Prelogar, I can't pronounce her name, what she is saying is that you're not giving any kind of nuance. You're saying ban minors from getting this kind of care, specifically if it's about transition. So you are specifically discriminating against trans people on the basis of sex. No, but the boys can get this is all equal. This is not about sex. The girls can get the boys can get it. Everybody can get it. No. But what you're saying is trans people can't get it if they are they're trying to get this service for their specific sex. If it doesn't match and they want to go to another one. And so that is a discrimination. That's a sex line that you are creating. And so it's discrimination based on sex, fool. And you're not giving any nuance. You're just fucking banning it all around in the state. Shady. All right, so now we can listen. We all clear? To what extent are their questions sincerely inquiries, and to what extent are they strategically attempting to shape the discussion or opinion of their colleagues? All of that is happening. That's what happens in the court of law. I think they're all sincere inquiries, but they are to the extent, like you said, strategically attempt to shape the discussion. That is what happens in law. That is what happened. You are shaping the opinion of your colleagues, shaping the opinion of how they're going to vote. That is what you're doing. So you're presenting evidence and arguments to shape that opinion to make them vote either in your favor or in. That's the whole point of the two lawyers, the lawyer for the U.S. and the lawyer for Skrmetti. You literally are presenting your arguments and y'all going back and forth with the judges to convince the judges to vote in your favor. So all the things that they are questioning is going to have some type of strategic attempt to shape the discussion. It's going to have that. That's why they're bringing up these other countries' cases and these developing. Well, there's so many things that are developing about this subject that's really coming up, and I think it's kind of too soon to make decisions because these things are developing. You're going to hear that a little bit later, where they are bringing up these things because in this new era of anti-trans rhetoric, there's things that are being developed to work against us. And so they're using it as an excuse to kind of throw it back down at the states instead of them making a decision. They would much rather throw it to the states because then it will be just like adoption, where we ain't got to deal with it. The states can deal with it because they know certain states are red, strongly red, the Florida, Texas, and so it takes it off their hands. But they are all trying to shape the discussion.
General, I wanted to get your thoughts first on why one should think of this as primarily
Elena
classification.
Keegan. I think that's
another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is a discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state. And it's true, it arises in the context of medical care for transgender youth. But here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here, insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that
Okay, so I want to explain that a little bit more. All right, so like Elizabeth just asked, are they strategically attempting to shape the discussion? Yes. This is what lawyers do, okay? Lawyers there's an angle that they're choosing to go with when it comes to convincing the jury or convincing the judge of, like, let's say it's a criminal law, the innocence of their defendant or plaintiff, or I don't know what's the difference. Not what's the difference, but I can't remember exactly which one it is, defendant or plaintiff. Whoever the person they're defending as the lawyer, they have to go, or they're trying to get fucking charged. Whether whoever it is, the lawyer is coming from, they're picking a particular angle to come from, and usually the gamble is this the best angle for me to get my desired outcome? If I'm trying to convince you that this motherfucker is guilty or this thing that's happening is wrong, what is the best angle for me to do that with? Okay, that's what lawyers are doing. What's the best angle? And so what Justice Kagan said is, from what I'm to understand, we're talking about it on as a sex line, like a male and female line, okay? But why can't we talk about this on like a trans and cisgender line? Because that's what this feels like is discriminated against, because of trans people and cisgender people. But trans people specifically aren't necessarily considered a class of people yet. It hasn't been really fully defined because we are kind of now being grappled with, okay? And so, but what Elizabeth is saying is, yes, I agree, Judge Kagan, that this is discrimination on that line too, but the angle that I'm going for is what has already been decided in other cases. So it's just easier for me to go on the angle of sex, male and female, because we've already got cases. And it just will be easier because if I focus on this trans versus cisgender stuff, it hasn't been well defined yet. It hasn't been well defined as sex. We've already had a lot of cases define what sex discrimination is, and this case that we are arguing still aligns with that line that you're making about sex. And so she's like, yes, I agree, it is trans discrimination specifically in regards to trans and cisgender, but I want to go in the angle of sex because I already have tons of cases to support, and y'all have already judged on cases like this to support that this is defined as a sex line and it is discrimination based on sex. Y'all follow me? All right.
is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock, or the one the court would confront if the statute simply discriminated on the basis of transgender status. Because here the legislature actually put the sex classification into the base of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means.
So Elizabeth says, I was asking more on the point of view of the justices talking to each other. Yeah, the burden is on the lawyer to argue their case, but I was more talking about the dynamic of the 9 individuals. Yes, they are. Yes, I understand that, but they are talking to the 2 lawyers to defend their case. They are talking in the presence of the other justices, but they're not really talking to each other. They're talking to the lawyers. Because ultimately, this is a conversation between the justice body, the Supreme Court, not the individuals. The individuals make up the whole. The whole is hearing arguments from this side, hearing arguments for this side, and you are trying to they're having a conversation with both sides. It's not with each other. Yes, they're in the presence of the other judges, but they are having a conversation with the 2 sides, the 2 lawyers from each side. So ultimately, yes, they're with each other in the room, so they're a part of the individuals are part of the conversation with each other, but the body of the court is talking to the 2 sides, the 2 lawyers. That's the conversation that's being had between the body of the court. That's 1 point, this side and this side. So it's only 3 points. It's not do. This is one body. So you got to think of them as one body that just have different questions. And some of them are going to lean conservative and some of them are going to lean progressive. And Brianna said, it's also not enough public support for that nuance yet. Boom, we haven't worked that out. We are in the process of working that out. All right, let's go.
To do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will, for a person born male who wants to get to puberty already,
Right.
And you said that that's a kind of under-inclusion problem. And, it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because you seem to want to say, no, you can do heightened scrutiny, but you can also make certain deferential moves towards the legislature. And I guess I'm pressing you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated for all other purposes, and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny, precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, want to ask about our role here and pick up on the Chief Justice's questions.
Explain that a little bit more, Brianna. What is Romer versus Evan? Let me look that up. (1996). Romer versus Evan was a landmark 2096 Supreme Court case that struck down a Colorado constitutional amendment that excuse me, that prohibited laws protecting LGBTQ people from discrimination. Oh, damn. In 1992, Colorado voters passed an amendment which prohibited the state government from passing laws or adopting policies that would protect LGBT people from discrimination. A legal challenge was launched, and the Colorado Supreme Court upheld the amendment. This is the case that went to the Supreme Court. The decision on May 20th, 1996, the Supreme Court ruled 6-3 that the amendment 2 violated the equal protection clause of the 14th Amendment. The court case decision, y'all have to really know the history of the 14th Amendment. There's a documentary on Netflix that give you like a good baseline of the 14th Amendment, and it is hosted by Will Smith, and it's called Amend on Netflix. Check it out. Because these 14th Amendment, that is spicy. That is like the crux of most of our rights. The court decision made clear that anti-gay sentiments cannot justify governmental discrimination. Romer versus Evan was the first case in which the Supreme Court ruled that discrimination based on sexual orientation violated constitutional rights. The decision was a victory for LGBT rights activists who saw it as a sign that the court may be moving from its previous conservative stance on gay rights. And as we can see, we have a way more conservative court nowadays. Now here, what's that, 25 years later? Wait, is this, or 30 years later? How many years is that, 30? It's about to be 30? Yes. And so what Brianna is saying is that this court case, Romer versus Evan, is this case that we're battling now is our version of that case that happened in 96. And so, and this is a point that I want to make out. If you are listening and you're watching, you're enjoying the conversation, make sure you thumbs up, engage with the content. Another thing that I want to share, one of the reasons why it's important for us to have an intersectional mindset about who we fight for and who we support and who is oppressed, blah, 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 how the many Black feminists of our Black feminist ancestors and scholars have said about centering the least among us. I want you to think about how we have gotten rights in this country, okay? I meant the case that Lawrence versus Texas overturned. My bad, that was the wrong case. Hey, Miss Carol. But I think that's a good case though. But the point I want to also share out. Okay, so in our country, when was when was our turn of Bauer versus Hardwick? Okay, I'll look that up soon. When do we legend, like in regard to the legend of when we got our rights as queer people? When was the moment? Normally we say like Stonewall, even though there's tons of shit that happened before Stonewall. But so we say Stonewall when Marsha P. Johnson threw the first brick, and we know that Stormy was there, all that kind of stuff. So we usually say Stonewall. When did Stonewall happen? 1969, June 28th, 1969. So that is when, queer people had enough, and the legend is that it is trans people that was at the center of that. Now we know that it's trans people and a butch lesbian. I hate when y'all erase that. I know trans people, we need that kind of visibility because we've been erased, but I don't want to simultaneously do some misogynoir shit and erase the Black butch gender nonconforming person that was a part of that battle, because Black masculine of center lesbians are usually at the forefront of fights. And so I don't want to erase them. Okay, this is in 1969, June 28th. That is the moment that our queer rights, we was fighting for them, and the moment that sparked the change. Now, based on what I just read about that case, that's 1969. This was Romer versus Evan was 1996. So that's like a 30-year difference. So even though trans people was at the center of that fight in 1969, we don't get protected from discrimination until 2020, but the gays get protected in 1996. Even though we were at the center of the fight that started the revolution for sexual pride and protection, and the shift in the culture to care about sexual orientation, even though we were at the center of changing that, regular cisgender gay people benefit from it first. And this is not Oppression Olympics. I just want y'all to think about it. They got the protection first. And here we are 30 years after that. So this is 60 years. Even though we are at the forefront, the cutting edge of fighting for our rights, we're throwing the first brick. And so when we have this counter rally shit, like when we have queer people, Brianna just talked about queer people being at Skrmetti at the court case as a counter rally against trans people, queer people. In my brain, it's like, how dare you get up off your ass to go down to the Supreme Court and be against the people who fought for you to get where you were, to get where you are, even faster than us. Y'all don't think that that's crazy? Where is your integrity? Where is your loyalty? Where is your empathy? The 14th Amendment is everything. The Equal Protection Clause should be foundational and reinforce everything or not, and could be more important than the Bill of Rights itself. Could be. I think it is. I agree. I hate when gays act like the T is not the LGBT. And well, there's a lot of trans people that don't feel like we should be in there. And there is a nuance, but I feel like it's all gender non-conforming. Like people love to say, well, we're not sexual orientation, we're gender identity, but we are all gender non-conforming. We are all gender. We are saying that what the roles that the society says of gender, we are going against it. Some of us it's about gender identity, and some of us it's about sexual orientation, and some of us it's about both. Because we forget that there are gay trans people. So we are all gender non-conforming. We're going against the rules, against the gender roles that society has set up for us. Got it? And so making it seem that kind of elitist, that kind of tribal, it's kind of elitist. Sometimes it's tribal. Sometimes making it seem like we're not connected at all. I think that does a disservice to us, and it allows people to be to get in the mindset of they're not one of us, and disconnect how our oppression is connected. You think that when they roll back our stuff or stop us from, not even roll back, we ain't got it yet, when they stop us from getting our stuff, the next step is to go back and undo 96. Thumbs up. 96, right? They're women, cisgender women or birthing people. They already consistently have been attacking abortion rights, body autonomy. They consistently, and it took them forever because they had their law in the 70s. And yes, it took them all the way till now, this honey's 55 years to undo it. You think they can't go back to 96 and undo it for the gays? I don't know why they think that they're not a part of this fight. I don't know why they think that they're not a part of Project 25 or any one of their plans to undo. There literally is a case coming up to stop you from getting married. Like they're waiting for the case to come up so they can undo it in the way that they undo Dobbs. Are you not getting it? Y'all out here with the blessing of PrEP, with the blessing of, you get what I'm saying, almost coming to the end of the AIDS epidemic. So y'all out here fucking raw, getting your booty holes pounded. They're about to criminalize your sex again, your type of sex. Because that's what Lawrence versus Texas, if they undo that, that is what stopped it from being criminalized. Are you not getting that you're on the chopping block too? Because you're too busy being transphobic and hating us? Or trying to separate, and it may not even be hate. You're trying to separate yourself from us when we're all gender non-conforming. Okay, I wanted to go look up Bowers versus Hardwick. All right, Bauer versus Hardwick was a 1986 Supreme Court case where the court ruled that Constitution does not protect a right to engage in homosexual sex. Oh, that's for your it does not protect the right in homosexual sex, upholding the Georgia law criminalizing sodomy. So this is what Lawrence versus Texas gave us the right to do. This decision later overturned Lawrence versus Texas, overturned by Lawrence versus Texas, which recognizes the right to privacy in sexual matters, regardless of sexual orientation. So I want you to clock that. It's the privacy of it. It's what you do behind closed doors is your business. And that is protected. That is an assumed protection. So almost, so if you a racial context to this, the Bowers versus Hardwick would be like the Dred Scott case. Am I right or wrong, Brianna? Like it feels like you know how Dred Scott was a bad anti-black decision, and then we had to get Brown versus Board of Education to kind of overturn it. That's what it feels like. Like Bowers was like the Dred Scott, and Lawrence versus Texas was fixing it. Is that right? Let me see. All righty, let's go.
At the beginning,
It's Brett Kavanaugh.
who decides? You've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20 plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law. And I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here. But when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is, then you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, the way you would think about this is
a rapist, by the way.
It's all boys and girls from transitioning using certain medical treatments, and it doesn't say only boys can do so or only girls can do so.
Well, I think the problem
he
with
clearly
trying to
doesn't
put that
respect
transitioning
sex-based
label
lines
on it
anyway.
as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that for what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety for minors. You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind and want to detransition, which I don't think we can ignore. We can't ignore what you're talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or rational basis, those justifications for the state, how do we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
So let me react to a couple of different points you brought up. First of all, I do think that the standard of review very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that anytime the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern. And here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender affirming care at all. And also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility. So I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity. With respect to hormone use, there are some effects on fertility.
Come on, Elizabeth, word out.
That many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks. And as I said before, I can understand that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB1 expressly permits, like on intersex individuals who often have surgeries as infants that might permanently affect their fertility. I would also say that if you are concerned about fertility, there are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rates of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is, you have this population of adolescents, and there are documented very essential benefits for a large number of them, and maybe a small number that will regret this care, just like with any other medical care. But for the state to come in and just say across the board, you can't have the medication because of your birth sex, we don't think that's a tailored law.
You acknowledge there is some group.
So we get what she's saying. She's saying, sweetie, you telling the girls they can't start early because if they don't start, if they wait till 18, baby, all this they got to go through. If they are trans men, they got to go through period and da 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 da, all the way up until they're 18. That's a fucking triggering. Then if you're a trans woman, honey, that jawline gonna get strong, that Adam's apple gonna get strong, that voice gonna get deeper, that beard gonna get thicker. Everything that if you have the support of your parents, you have the support of your doctors, everything that you can avoid, that you want to avoid as a trans person, because most people do not detransition. It's 1% of this 1% of the population. Most people do not detransition. And so if I have the support of my parents, the support of my doctors, I want to do this, and you're telling me I can pause it to give me some time to think about it, and then bam, I can do what I need to do, and I don't have to have the effects that testosterone is going to affect my body. I ain't got to go get the damn FFS. I ain't got to spend all of this money to undo what testosterone has done. I ain't got to go get the voice surgery. I ain't got to go get blah, 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 blah. There's so many things. We know when a girl starts off young, she be looking of the sea. We know when they start young, it can just help their transition go along. Not just on a physical level, but on, I have my family support. Do you know how rare that is? I have my family support. So not only do I can have the medical and physical transition be on my side, but I also have a community of people, my doctor and my family. And you trying to shit on that? Get out of here. So yes.
Group though, who later changes their mind and wants to detransition. That doesn't defeat your case. I just want to make sure you acknowledge there is, as a factual matter, some group of people.
Yes, we're certainly not denying that some people might detransition or regret this care, but all of the available evidence shows that it's a very small number.
Then to pick up on the Chief Justice and Justice Alito's questions.
Yes, Trishan, they talk about that later.
Evolving debate. I mean, just in the last couple of years in Europe, big changes in terms of how they're thinking about it and how they're thinking about these risks and benefits that you and I have just been talking about and you've been elaborating. If it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as, pretty heavy yellow light, if not red light, for this court to come in, the 9 of us, and to constitutionalize the whole area when the rest of the world, or at least the people the countries that have been at the forefront of this, are pumping the brakes on this kind of treatment because of concerns about the risks.
We certainly are not asking the court to set forth some bright line constitutional rules in this space that is going to really take further debate and evaluation of regulatory options away from states. We think, as I mentioned, that the court really only needs to decide the first order question here of whether this law classifies based on sex. I think that's entirely distinct from some of the concerns you've identified about what justifications the state has.
Do you think that West Virginia law you mentioned is constitutional?
I think it would likely satisfy heightened scrutiny. It hasn't been subject to adversarial testing because I don't think anyone has sued to challenge it. So I haven't looked at the record that West Virginia would build, but I do think that there is room here for states to enact tailored measures to try to guard against the kind of risks that you're concerned about and that the state has identified. And
last topic on the heightened review, and you say all we need to do is do heightened review, and that's kind of a minimal step. I mean, I'm not sure really that the follow-on effects of that could be pretty significant. I think Justice Kagan alluded to that in her question, or at least raised that as a question. And I want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports, basketball, swimming, volleyball, track, etc., notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case? So can you explain how intermediate scrutiny would apply to women's sports?
Yes, and just as a threshold clarifying point, I want to be clear that when it comes to access to sex-separated spaces like sports and bathrooms, courts already recognize that those are facial sex classifications that trigger heightened scrutiny. So it's actually not the question teed up here about how to classify the law in the first place or how to identify whether it's a sex classification. Instead, that's taken as given in that litigation, and the entire focal point of the disputes in those cases has been, well, does the state have an important governmental interest, and does it need to draw the lines to exclude transgender people?
Right, but how would intermediate scrutiny, which we may not, if we went to intermediate scrutiny, there's a possibility we would apply it here. How would it apply to, in your view, and maybe you don't have fully informed views, which would be fine, but how do you think it would apply to sports?
So courts have split on that issue, and I hesitate to try in a vacuum without an actual factual record to try to opine on the state's justification and whether it will satisfy that standard. It's obviously a different set of governmental interests that are being asserted there, and those would have to be analyzed in their own right. But I think that this court, if it wants to preserve space to make clear that nothing here should be understood to affect the separate questions that are arising there, the court could very well do so, and we would have no objection to explicit language saying this decision does not in any way or should not be understood to affect the separate state interests there that have to be evaluated on their own terms.
Okay, but looking ahead, do you think it's logically possible, as a matter of constitutional decision making, to say that laws like the ones that one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny? Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think one readily apparent difference is that in the context of sports, there are arguments made that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts. There's nothing like this here. Allowing transgender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people. And so I think the court could well understand the statute here to fail intermediate scrutiny, even if it would survive there.
Come on, Elizabeth.
Justice Barrett?
Morning, General. I want to pick up on one of Justice Kavanaugh's early questions. He pointed out that the burdens of the law fall equally on boys and girls because neither can transition. And you responded that it's kind of this sex classification or the expectations that one will conform to one's, biological or gender assigned at birth. Why isn't that more of an Arlington Heights argument about intentional discrimination than if what you're really saying or what the legislature is really saying is the burden of this is going to be equally applicable. Neither boys nor girls can have access to these drugs.
Listen, Amy Coney Barrett.
Because we want girls to be girls and boys to be boys, at least until they're old enough to decide otherwise.
So I think it would be wrong to overlook the fact that even separate and apart from any interest in conformity here or sex stereotyping, this is a law on its face that does not subject boys and girls to equal treatment. And you can see that if you look at how the law applies to some of the individual plaintiffs. Take Ryan Rowe, who is one of the individual plaintiffs here. He wants to take testosterone in order to live and identify as a boy, and he's prohibited by SB1 from doing so because his birth sex was female. But if you change Ryan's birth sex and suppose he was assigned male at birth, then SB1's restriction lifts. So he is not being treated the same as a boy, who was assigned male at birth. And I think that is the kind of quintessential test the court has applied for purposes of identifying when there's a sex classification.
So what would your argument be if a new drug is developed within, say, 2 or 3 years that just the only purpose of the drug, there's no precocious puberty purpose or anything like that. The only reason to give this drug is it targets minors who have gender dysphoria particularly. And a state passes a law, the FDA approves it, so it's available in some states, but a state passes a law saying no one has access to it. So now you don't have that whole thing falls out.
Yeah. So that would not be a facial sex classification. And there, I do think that you would have to apply an Arlington Heights type of analysis to see whether the context and history demonstrate that actually the state was intending to treat people differently based on their sex. But I think that would function very differently from
Why don't you have an
SB1.
Arlington Heights argument here too? Because I take it one thing you think would be wrong with that law is the stereotyping function.
Well, I think that Arlington Heights doesn't seem like the natural doctrinal home for a law like SB1 that says on its face you can't act inconsistent with sex. And I take your point about that's applying some equal rules to boys and girls, but that's true anytime you have a law that says you can't act inconsistent with a characteristic. That means that there's going to be a restriction on males and a restriction on females. It's true of any other factor too, inconsistent with race, inconsistent with religion. You might say, well, that's not just singling out one religion or one race or one sex for disparate treatment, but I think it actually increases the number of classifications when you're applying parallel restrictive rules on the basis of a protected characteristic across the board.
So let me return to
Period.
Justice Kagan's questions. She asked you whether really the more natural way to think about this is that it is discriminating on the basis of transgender status rather than, I feel like trying to make the Bostock-like argument, holding all things equal, or that you have to do this by reference to, biological sex, feels like an odd way to solve the problem. And kind of that hypothetical I gave you about the drug that just has the transitioning purpose. So if we just head on confront the question which you raise in the second part of your brief about whether transgender status should be a suspect class, one question I have is, at least as far as I can think of, we don't have a history of de jure, or that I know of, we don't have a history of de jure discrimination against transgender people, right? You point out in your brief that in the last 3 years there have been these laws. But before that, we might have had private societal discrimination. But I don't know of, but is there a history that I don't know about where we have de jure discrimination? And my concern about it is this: all of the other suspect classes that we've recognized so far do have that long de jure history of discrimination. And, the Equal Protection Clause applies to state action. So it feels like an odd fit to say that in their private lives, people have discriminated against transgender people. Therefore, we're going to treat it as a suspect class for purposes of the Equal Protection Clause.
So I think you may be right that the historical discrimination against transgender people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here, and it hasn't just been confined to private actors. I think that if you actually looked at the facts, there's a wealth of evidence to suggest that transgender people throughout history have been subjected to violence and discrimination and maybe lost employment opportunities or housing opportunities, even in contexts where there might be state public employment at play. And of course, that's especially reflected now in the law, where there has been this, I think, attention and focus on trying to limit transgender people from being able to live and identify consistent with their gender identity in our society. So
I want to pause that right there before we continue, because she is mentioning something that you might not know. The de jure is spelled D-E, like French, D-E, and then separate word J-U-R-E, de jure. De jure discrimination is when the law is written in a way that discriminates against a group of people based on their shared characteristics. So Elizabeth just said Amy Coney Barrett doesn't sound so bad. I mean, they all don't sound bad, but this is where you got to clock it, T. So what Amy Coney Barrett is doing, just like you said earlier, are they trying to, what was your exact word? I can't remember exactly what you said. You said they are, yes, they are the strategic attempt to shape the discussion. Okay. That is what she's doing, and it's bad. So she is trying to push her to go to the transgender thing, the transgender separation. And remember what we talked about earlier, we haven't fleshed that out yet. So that's not an easy path to a win. She wants us to go down that route because then they can just throw it back to the states. The goal of these conservative people, these conservative judges, is to throw it back to the states. So if they haven't worked out the details of the trans thing versus cisgender stuff, then you got to bring another case, baby, because we ain't worked that out yet. The goal is for her to throw it back to the states. So if you go outside of the realm of sex, which is we've already defined that, that's way more clear defined. It's defined very clearly. And so, but if it's trans, and that's sex discrimination. And so we've already had it. We've done it with race. We've done it with sex. We have not done that. We haven't got that definitive line when it comes to discrimination against trans people versus cisgender people. And so because that still is murky and a gray area, it makes us susceptible for them to throw us back at the states. So she is trying to, like you said, strategically guide the conversation in a direction, because that is what they do. And so they are trying to guide the conversation to where, I don't know if this is a de jure situation. And that's why Elizabeth just said, no, I think we have, it's tons of documented that trans people are being discriminated based on them being trans. We know that's documented. But we haven't had these court decisions made to solidify our rights until recently. Got it? So while she's articulate, she's a white woman, her intention is bad. That's what it is. And so she's explaining that we know that this discrimination against trans people has happened, but she doesn't want to go down the road of it being a thing about trans versus cis. She wants to go down the road that this is discriminatory based on sex. You're making that sex line. And we've already, the court has already said that we can't do that. So if they argue that point well, then they won.
So I don't even understand the state to be disputing the historical discrimination point. But if you're approaching this from the standpoint of saying, is this a group with a distinguishing characteristic that has no bearing on their ability to contribute and that needs some protection from the courts? I think if any group qualifies, this one does in light of the current laws and what might come in the future. And our basic argument is, if you can look ahead and say, maybe the states will ban medical care for adults who are transgender, maybe they'll ban adoption by transgender people or not allow them to be teachers. That doesn't look anything like the workaday economic regulation that just gets rational basis review. And I think the court could give effect to that intuition.
Yeah, and I don't want to be misunderstood to say that I don't think there's a problem or that there hasn't been private discrimination. I guess it doesn't seem analogous to me to say race or gender or national origin, those kinds of things, because we did have de jure discrimination to point to. And so I guess what I'm thinking is, when we are in the business of identifying suspect classes, in Cleburne, we expressed, and I'm not saying that this is analogous to Cleburne in that respect, but we expressed in Cleburne hesitancy, to identify groups such as the elderly, or the mentally disabled as suspect classes, in part because those are judgments that are pretty hard for courts to make. And at least de jure discrimination of the sort experienced by women, or people on the basis of race gives us something to point to if we're going to be identifying a new suspect class, which we haven't done for a long time.
Yeah, and I, of course, take that point, and I should reiterate, we don't think the court has to confront it here. But in the cases involving age and disability, I understand the court to have approached those issues with somewhat different reasoning, that age is something we all experience, that disability is a broad and diverse group, and that individuals with disabilities have been able to harness the majoritarian political forces to protect their rights. And none of that is true here. Transgender individuals are a discrete minority. I think there's no dispute that they are being subject to a wave of legislation across the states today. And I think that this is the kind of circumstance where the court could rightly recognize that heightened scrutiny should apply.
Last question. Do you agree with me that the resolution of this case has no impact on the parental rights claim that the Sixth Circuit also addressed?
That's right. I think we are not making a substantive due process parental rights claim here, and this court obviously didn't grant review of that issue. I will say that I think parental rights are actually relevant to the Equal Protection Clause as well, insofar as it's significant to me that Tennessee, in choosing to categorically ban this care, is taking a sharp turn away from how it ordinarily handles parental rights in the medical decision-making space. And Justice Kavanaugh said, who decides here? But when it comes to medical risks and benefits, the state's general approach is to say, parents get to decide along with their doctors and their children. And so I think from the standpoint of under-inclusivity, it's pretty significant that Tennessee now is completely overriding parents' wishes when they are best positioned to know their individual child and to have a good sense of whether the risks of this treatment are outweighed by the benefits.
But this isn't, I guess my point is, even if we decided that this wasn't a sex-based classification that triggered intermediate scrutiny, that would not prevent parents from still asserting the substantive due process right.
Yes, of course, I agree with that. I do think that the sex-based classification under Equal Protection Clause is the most straightforward way to think about what's going on here, though. Yeah.
Thanks.
Justice Jackson?
So I'm glad that you've clarified that how we characterize this law is
Ketanji Jackson,
on the table
Brown
today,
Jackson.
not the risks or benefits or the policies that justify it, but how we characterize it. And I guess I think there might be some confusion a little bit. At least I'm confused because there's so many lines that this statute could draw. The classification, as far as I can tell, is a line drawing, is the statute drawing lines, and there are lots of different ones. And Tennessee says this is drawing a line between people on the basis of age and purpose, and I totally see that. You say this is drawing a line on the basis of sex. I see that as well, but I guess my sort of initial question is, are those mutually exclusive? Do we have to choose between those characterizations? Isn't there a world in which this statute is doing both of those things? And the question for equal protection purposes is, if you're right that there is a sex-based line being drawn, then to the extent the plaintiffs are implicated by that line, don't we have to apply heightened scrutiny in evaluating their claims?
Yes, that's exactly right. And I think, of course, you could say this is a statute that classifies based on age and purpose and sex. Critically, we think that purpose incorporates sex here because the purpose is expressly defined in terms of treatments that are inconsistent with sex.
Right.
So I think the problem with the state's approach is to say, well, it's just purpose going on. You take one look at that, and that just dissolves down into drawing a sex-based line itself.
Can we put more flesh on that, though? Because I mean, even if we separate out their age and purpose, and we just say, okay, so how is this actually drawing a line on the basis of sex? I think I heard you say it a couple times with respect to some examples, but I think it would be helpful to get on the table exactly who's falling on what side of the line in a particular situation related to sex.
Yes.
Okay. So this is another example, Elizabeth. What Ketanji is doing, also strategically guiding the conversation. Ketanji is like, all right, can you put some more meat on these bones, baby? Let's talk about, because Ketanji is, Justice Jackson is guiding it to that line, that sex line, because I know where y'all going with trying to make this, to make this sex line argument clear. So let's put some meat on the bones and explain to me how people fall across these lines and how basically solidify your argument about why this is a sex-based line that we are creating. Boom, 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 boom. So she too is gearing the conversation, leading the conversation to make a point. And the point is that this is a sex-based line. In the way that Amy Coney Barrett was trying to like, why can't we make this about trans and cisgender? It's no de jure discrimination, even though it is, bitch, shut up. And so, yeah, right. And so we know, we see it. All this legislation coming up. Get out of here. And so, in the way that Amy Coney Barrett was saying, why don't we make it like this? She's saying, boom, let's get into the meat and potatoes of this sex line, this sex-based line that we're drawing. To talk about some of the people who are on either side of this line. And this is Elizabeth's response. What did Alumi say? Just arrived. Is it already started? Yes, we are in the beginning part of it. We are almost a little over a third, almost halfway through, but over a third. Definitely over a third. And we probably in that like Yeah, like that 40% done. Over a third, under a half. Um, and so Chase has not spoken. Chase is at the end, not at the end, but on the other half. Elizabeth is opening it and beginning it. Chase ends it. Um, I wish Elizabeth Proctor will the next 4 years. I'm sure Trump is likely to fire her and replace her with his own Solicitor General. I'm pretty sure. Yeah. Um, what else? Yes. All right. Let's start it. So this is Amy's response to Ketanji saying, Justice Jackson saying, yo, let's put some meat on these bones.
Yes. So the way that the sex-based classification is working here is that from the standpoint of any individual who wants to take these medications, their sex determines whether SB1 applies. John Doe, one of the plaintiffs, wants to take puberty blockers to undergo a typical male puberty. But SB1 says that because John's sex at birth was female, he can't have access to those medications. And if you change his sex, then the restriction under SB1 lifts and it changes the result. And my friends say, well, that also simultaneously changes the medical purpose of using these medications. We don't dispute that point, that it might also inherently change purpose when you're changing sex.
But it doesn't have to, right? I thought of an example in which we have a plaintiff, a person a minor, who would like to take this medication to affirm their gender as a male because the medication deepens their voice, for example. They want a deeper voice and they're biologically male. They're taking the medication because that's what they want. They, I think, can get that medication.
That's right. And
but
so
a person who is biologically female who wants to take the medication for that same purpose, to deepen their voice because they would like to live as a male, can't get it. Is that right?
Correct. And that is on the basis of their sex.
So the purpose is held constant with that example. It's not changing. What is changing is just the biological sex of the individual.
I think that that's correct. But even in a circumstance where you might characterize that as treating delayed puberty instead of gender dysphoria, if you said, well, there is a different purpose there, even though the effects are exactly the same and they want the medications for exactly the same reason, that doesn't eliminate the sex-based classification because sex only has to be one but-for cause of disparate treatment. And I think the state will say it's perfectly reasonable to treat different medical purposes or uses differently. We don't disagree, but that's something that's channeled to the application of heightened scrutiny. And if the state has a really good reason to say there's a danger in using these drugs if your birth sex was female and you want to deepen your voice,
right? That's Justice Alito's studies and all of this.
Exactly. That all goes to the application of heightened scrutiny, and maybe the state can prove it up and show they have an important state interest and they really have a reason to distinguish between who can have these drugs for which purposes based on their sex. But that doesn't eliminate the facial sex classification or provide a reason for this court to turn its back on 50 years of precedent saying, if you classify based on sex, you have to justify that.
And it's interesting to me that you mentioned precedent, because some of these questions about sort of who decides and the concerns and legislative prerogatives, et cetera, sound very familiar to me. They sound in the same kinds of arguments that were made back in the day, 50s, 60s, with respect to racial classifications and inconsistencies. I'm thinking in particular about Loving, and I'm wondering whether you've thought about the parallels, because I see one, as to how this statute operates and how the anti-miscegenation statutes in Virginia operated.
All right, clock that T. Justice Jackson is married to a white man. Justice Clarence Thomas is married to a white woman. And so I want you to imagine her looking over at Clarence. Is she talking about us, brother of the swirl? We in the swirl. We in the swirl, baby. And so what y'all trying to play? How y'all trying to play the game? This can be a slippery slope back to them times. And your wife and my husband, this could be a problem for us, brother of the swirl. So what we doing here, my nigga? What we doing? So explain to me, because it sounds familiar, because I have looked into this. I'm a judge. I know what that case does. I'm not like Amy Coney Barrett. I've been in this game and doing these things for a long time. She has nowhere near my level of experience. She was a DEI hire because she was white and conservative, a white woman and conservative. Clock that T. Clock that. I know what I'm doing. Okay, so let's talk about loving. And Clock, this is the first time that she brings it up, but she keep bringing it up. Looking down at Clarence Thomas. She wasn't doing this, but this is what she's doing in my mind. Bruh, brother of the swirl. Let's go see her response. No, he did not say loving needs to be looked at again. He said Griswold. He specifically did not say loving. He said Griswold because Griswold is contraception, because that's the next step. They want to overturn contraception. He wouldn't dare say loving because he is married to a white woman. He wouldn't say that. If you look at his dissension, he said, Griswold, which is a case about contraception. So check that out. Okay, let's see what she says about it.
Yes, and I think the court has recognized that the Equal Protection Clause was intended to force some changes in society and get us to think more closely about the way that people were being classified, including when that was based on overbroad generalizations of how we expect them to live and order their affairs. And the court has made that clear in the sex discrimination cases as well, where it said, sometimes these laws operate to disadvantage someone who falls outside the average description, and that person needs the protection of the court.
Well, and the thing I thought what was most interesting about the potential comparison to loving is that in that case, everyone seemed to concede up front that a racial classification was being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic, and in all other contexts, the court has recognized that as a facial classification based on that characteristic, and Tennessee even concedes the point when it comes to dress codes and to seeking a profession inconsistent with sex. But I think one other way to look at this, Justice Jackson, is that to me, it would be a remarkable proposition for this court to say that a statute that on its face says you can't have medications inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground. Thank you.
Thank you, counsel. Mr. Strangio?
Justice
Mr. Chief
Chase.
Justice, and may it please the court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too. By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
If you are successful, what would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB1 as applied to our individual plaintiffs.
So, in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex?
In practical terms, what it would mean is that an individual like John Doe, who was receiving medical treatment to undergo a typical male puberty prior to SB1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of review, that it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think, as the Solicitor General made clear in her remarks, that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the Sixth Circuit to apply that standard in the first instance.
Is there anything you would like to add? Maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus Bourne, unlike a case like Morales, and those where it was quite clearly simply stereotyping.
John Roberts.
Men have the same rights as women with respect to adoption and the liquor laws. This does strike me whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases.
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence, as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether a classification is benign, and many justifications for sex-based differential treatment in law were defended on the ground of biological differences and were upheld by the court under rational basis. And the role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counsel, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means ends calculation in this kind of medical context?
Amy Coney Barrett.
I agree with you. I mean, I can see your point, like, well, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, undeniably in areas of public health and evolving science. And the court repeatedly made clear that, yes, of course, the states have latitude through their police power to regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some. can I just, this
Sure.
last follow-up, but even in those COVID-19 cases, courts weren't, and we certainly weren't diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression.
Sonia Sotomayor.
Correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie and exactly what the difference is between that 1% of children who receive these treatments expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we addressed this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, Counsel.
Could we explore what intermediate scrutiny might look like in operation in assessing laws like Tennessee's? So the Solicitor General on page 48 of her brief lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions
Alito.
things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with a decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in response, Justice Alito, and the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law, and if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements.
Wait. So I want to talk about this because what he just did to me is like an appeal to extremes. He is saying that if we do the intermediate scrutiny and we allow the states to kind of get in the weeds of all this should be these kind of delicate, customized. We got every judge got to come into the case and see exactly what's going on with the minor. That is just going to be an overwhelming feat to do. So I feel like this is an argument of extremes. Like he's making it seem like this is just going to be a super, super extreme thing to do and blah, 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 blah. It's similar to saying like, let me give you a more layman. So say that we're having like a dress code issue at a school and the student and it's about the student saying we want to be able to wear hats to school or whatever, and the person who's making the decision says, oh, if we allow the students to wear hats, then we have to decide which hats they get to wear and the style of hats they get to wear, then soon we'll have to that's just gonna take too much time of us worrying about what type of hats is, or if they'll be wearing pajamas or coming to school completely unprepared because their clothes are not right. And it's just gonna open up all these questions about style and clothes, style of hats and clothes. That's appealing to the extreme. And that's what I feel like that he just did. But y'all tell me if y'all agree.
Have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of it, looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare. And we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point, if I could, to the history of discrimination. And there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
I think
somebody was trying to make it.
Yes, I think it was me. And the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence. And I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It's not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely how
this is Justice Roberts
were going to be, what the remedies were going to be.
I actually like Justice Roberts.
To that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, or not the Tennessee court, this court is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications. It's more questions of constitutional allegation of authority. And, we might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor. And particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Well,
Just what you think.
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely.
I want to pause right there because I want to say something. Now, you hear what he just said. He said, should we listen to what's going on in the UK from such and such years ago or 3 years ago? Blah, 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 blah. It just feels like that we are bereft of expertise to make this decision. It seems like y'all bereft. Y'all most of y'all is penis-toting men, old penis-toting men, and y'all clearly don't have experience with birth and shit, and y'all love to jump in like you an expert around what's going on with pregnancy, and you don't have any access to that information. And even with the doctors telling you, the expert gynecologists telling you that they need to be able to make decisions around people's lives when it comes to reproductive justice care, those experts are telling y'all what's going on, and y'all still not listening to them. So why all of a sudden being an expert about some shit matter to you? Now, all of a sudden, you bereft of expertise to make a decision about trans lives. Oh, we might not be ready to make this decision, but y'all ready to make the decisions around jobs? Y'all ready to make the decision, life and death decision around reproductive justice? It's crazy. Okay, before we start, let me go up and see what's being said. Elizabeth said, do we have social contingents in fair question for the community? Do we have social contingents is a fair question to community. I don't understand that. What do you mean by that? Explain that. But the number of kids who are reported on those puberty blockers don't add up. Williams Institute says 300K kids. Link me to that Williams Institute case study. Identify or been diagnosed trans since 2015, but only 5,000 or so have had these drugs. Well, that there's an access thing too. There's a tons of trans people who don't have access to be in studies or have access to therapists. Especially, a lot of times these studies are created a long ago when we didn't have access to everything in the way that we do now. So that may be skewing the numbers too. It could be people who identify based on, where I don't know how they collected the data. So I would need to know that. That's why I said link it so I can know what you're talking about. Diagnosed. So a person who, you can definitely have more numbers of people who are identify as trans as opposed to comparing it to diagnosis. And then if you compare the diagnosis to who actually has access to the treatment, so those numbers are going to consistently go down. So if the whole thing is saying 300K, I don't know about 5,000, but the number will be lower just based on access. Java said is clearly established in the science. Yes, it is. There shouldn't be any disagreement. Why they keep saying birth sex and not assigned sex at birth? I think that those are politically correct terms that if you're in community, I don't think that there's much difference in those terms. I know saying assigned sex at birth can be more politically correct because we want to emphasize that it is assigned and we didn't make that decision. I understand why you want to use that language. It's similar to how I say it's similar to how people say I'm a trans woman, and some people will say a woman of trans experience. Tomato. I understand why people want to say I'm living a woman of trans experience as opposed to trans woman. And, that adjective for some people feels uncomfortable. They want to emphasize the womanhood. I'm a woman of trans experience. But it's tomato, tomato, girl. We getting into semantics. I think a shift that I made maybe like 10 years ago, sometimes we would say, oh, I'm living as a woman, instead of saying I'm living in my truth. When I started to walk in my womanhood, or because sometimes living as a woman means that, like, almost like you putting on a costume as a woman. When I started dressing like a girl, or when I started to live as a woman, it's like you're not a real woman, you're living as one. A person, you see what I'm saying? So that language feels really, really weird. And so some people started to say, when I started to live my truth, or when I started to walk into my womanhood, or you get what I'm saying? Those kind of nuances. There's a politicizing and a community accepted way to say certain things, but certain ones are so close that it's almost like it's kind of silly to go down the rabbit hole of semantics, particularly birth sex and assigned sex at birth. I understand how someone might want to use one over the other, but in this context, we know what the fuck they mean. And so we don't want to go down, we don't want to kind of get distracted into semantics. You know how I hate when people have the conversation about, I'm just a woman, I'm not cis, and da da da. That's a distraction. That gets you. I don't even have those conversations no more. I don't. Is anybody that's on the level of complaining about using a word that we did not make up? Cisgender is a prefix that's been around, that's attached to so many other words. No. If you are to the level, if you're type of turf or a transphobe or a bigot that's to the level that's making a big deal about being cis, you don't have the intellectual capacity or integrity to have a conversation with me. So I don't even have a conversation with you if that's the level that you're on. It's almost like me having a conversation with like a Ku Klux Klan racist. I don't have conversation about my humanity or my inferiority with the white man. I'm never going to have that conversation, because if you think I'm superior, I mean, you think that I'm inferior to you, and that's your level of understanding, we don't have the same moral compass, and I'm morally superior than you, and on intellectually superior than you. So I'm not ever going to lower myself to have that kind of conversation to justify my humanity or justify my worth based on my race with you. I'm never going to have that conversation. And I feel the same way about having a conversation about cis or trans. I'm never going to, if that's the level that's where you're at, I'm never going to meet you on that level. Sorry, babe. I'm never going to meet you on that level. That's for the young girls who want to argue, who wants to waste their time and try to convince you that cisgender is it's not a slur, and it's not. I think that is a distraction. Does that make sense? Does that, how I'm explaining this make sense to you? Why I don't get into those kind of conversation? Yeah, I don't entertain those kind of conversations, because you are not, to me, you are bereft of intelligence or integrity. So you intentionally are trying to distract me from me from me wanting my rights as a trans person, wanting my dignity as a trans person, all because you are making up this fake this like fake argument about a word that I did not create, that I didn't make up, that is not a slur. You see what I'm saying? So like, you literally looking over, I'm out here getting killed and harmed and having Supreme Court justices argue about my rights as a person to exist, and you're talking about, oh, I'm offended by cisgender. Oh, you guys want respect and want to be called a woman and want to be called she, but you're calling me cisgendered. Oh my God. Fuck you, bitch. Suck my dick. I'm not having a conversation with you. Fuck you. Boom. I don't even entertain those conversations with those people, because most people who are on that ignorant level, you can't change their mind. You can't change their mind. There's no point in wasting your time. If somebody has the patience to do that, have at it, Hoss. Enjoy. Diamond Stylz does not. So, yes. What else? But if you care about the rights of all to do the work, however tedious it may be, to make sure that T are crossed and I's are dotted, everything should be up to scrutiny if it's important. If it's important to analyze, as long as under doctor's care. He defended gay people as a lawyer. He's somewhat reasonable, but votes in his own weird way for institutional himself. Yes, he's very that he kind of, and I don't want to he be conservative too, but he's the closest to in the middle of them other people. Um um they keep referring to Europe example as if it isn't any other places. There's just some long standing case studies and large cases that some of those northern European countries have been working on because they've had progressive pro-trans care for a long time, and so that's it's just long standing. Wade, hey, it's crazy. Elizabeth, before Trump put his choices there, he sometimes would vote with the liberals and dissent. Yeah. He saved Obamacare. He also saved our he's one of the judges that saved in 2020, June 8th. He's one of them that voted in our favor too. So he's not all just always bad and always conservative. They stay in the pants of people is disgusting. Man of woman experience, huh? A man of woman experience. Okay, I hear you. A distraction indeed. Facts. It's a different world since boys don't cry for sure. We were not even on the map. Hey, Diamond in chat, just getting on. Hey, Brandon. All right, so y'all ready to continue it? Let's see how much more time we got. Oh, what is going on? Okay.
Absolutely, it is not. I merely use that example to say that the court has not
Back to
hesitated
COVID.
to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all of their contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here, what they've done is impose a blunderbuss ban, overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas?
The point I was getting at with respect to remedies is normally in equal protection cases, there's a difference between one group and another. And born, it would be that the women could buy alcohol, but the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys. And what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
okay, let's change. What if, would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to make discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose. And what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth sex and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that some should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
We have said that having...
All right. So I did a video years ago. There was a trans girl who detransitioned, and she was kind of popular in the trans community. And it was this whole rigmarole about her detransitioning, because she didn't just detransition. She went on to make these videos. She went on to be like a church. You know how people are when it comes to they'll detransition and then become like these church prophets and talk against trans people, because they are, they have found the Lord, and I've been delivered. The one guy, his was more about homosexuality, Andrew Codwell, but they kind of go on that kind of rant where they talk shit about trans people or queer people. They get off the boat and then try to sink the boat. And so Jackie Perry, I don't know who Jackie Perry is, but that is a video that I talk about it. It is called The Journey of Personal Validation, Detransition. And so that is my thoughts, and that is an old video of mine. That is my thoughts about detransition. And while that conversation was sparked to that conversation was sparked by individual, it's what I think about transition in general. If you're watching, make sure you thumbs up. If you just came in, make sure you thumbs up. And so my idea around detransitioning, while yes, people detransition is a really, really low number, I want you to listen. I think that sexuality, I think that gender identity are very, very nuanced things. I think sometimes it's similar to, it's like a kid. You can warn a kid about the downfalls of drugs. You can warn the kids about the downfalls of drinking. You can warn an adult about all of these things. And they will, no matter how you explain it, how good you explain it, how much they trust you, how much they believe you, they still have to go smoke some weed just to have the experience of themselves. They still have to maybe do a bump of coke. Not all, I'm not talking about everybody, but they might have to go do some coke because they're so curious about experiencing coke. They might do it. Or you can warn them about pregnancy, you can warn them about sex, you can warn them about whatever, and they still got to fuck something because it's just natural for them to have that urge, and they still got to fuck something, period. There are some people who have to experience things in order to make their decision. So there are going to be some people who have to try to transition in order to figure out that transition is not for them. And sometimes they go far, 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 far down the road of transition and then have to do a U-turn before they realize that this was a dead end. It can go far. And there's no way to avoid it. It could be somebody who went through all the protocols, got their therapy, they went and did their 2 years. None of this stuff is along the lines of rules anymore, but old school rules. They could go to the therapist, they could do the 2 years of therapy before they could go full time. They could do all the stereotypical stuff, and then bam, 5 years in, they like, maybe this isn't for me. And then there are some people like yours truly who I knew when I was younger. And once I made the decision, I never thought about going back. This has been the most consistent, beautiful blessing of my life. Have there been some barriers about my transness? Absolutely. I have been fired from 3 jobs that changed the trajectory of my life because I was trans. Has it had negative impacts? Yes. But my life, my mental health has become substantially better once I decided, and how I related to the world, once I decided to live in my truth. That's how I experience my own transness. Other people may not experience that. I know some people. There was a girl who I grew up with. I feel like she became trans because she just so happened to be pretty and passable. But I think and I think because, and this is my only speculation. Let me say this. This is not speculation whether or not she regretted becoming trans. She told me that out of her own mouth. But the reason why is my speculations. I don't think that if she was a butch queen, she would have, when we were growing up, I don't think if she was a butch queen, she would have garnered the popularity and the citywide acclaim just being a butch queen. I think because of colorism, because of all those kind of things, that she wouldn't have been like a sickening butch queen. She would have been a regular butch queen that nobody would have paid attention to. But because she became a woman and was actually exceptionally passable, and she had a style, she had just a style to her that was amazing. So she just was, because she looked how she did as a girl and was attractive as a girl and had fashion sense that was perfect, it made her popular in community, and that popularity can be intoxicating. And so I'm finally getting I'm sorry, not decision. I'm finally getting attention revolved around my identity. So I go down this road where I'm going to get back alley silicone that messes up my titties, messes up my hips. My cheeks. I'm getting all these things that later on regret getting, but I'm just trying to be a girl, and I'm passable, and I'm getting my life. I'm walking bars. I'm doing drag. I'm doing all of these things that are making me popular and getting me attention and giving me prestige. But once I hit my 30s and I have hit a ceiling in whatever career I have gotten into, excuse me, I have hit a ceiling. I'm no longer getting that kind of attention. There's new girls coming up that are just as sickening as me. I'm no longer in the way that I was when I was a young coming up girl. I'm no longer getting that attention. And so now I got to think about my life. And now I'm having regrets about transitioning because I really didn't want to transition in the first place. It just so happened that I was passable and pretty. But I really just should have been a butch queen. And so, but she wasn't going to detransition. She was too far gone. But she had conversations about detransitioning with me and other people. And so there's some people who say, fuck it, I'm going to detransition and I'm going to get my breasts cut off. I'm going to go back to being a boy. Sometimes they go as far as gender reassignment surgery. Sometimes it's just everybody goes down the road in different ways. So sometimes you got to turn around. My only request, my only ask is why I don't feel anybody should silence you in sharing your story, your reasoning. What I ask is that don't talk about your transness as if you are all of us. Don't get to going on conservative platforms and saying, because I made the mistake of transitioning, all the rest of the trans people is making that mistake. And the world and the medical industry is convincing them that they're trans because you made the wrong mistake. My decision to be trans, my decision to live my truth. And I say that my decision to live my truth, not my decision to be trans. I don't feel like I asked to be trans. I feel like I chose to live my truth. I could be in the closet and not transition and be some weird ass fucking butch queen, but that ain't me. I knew I had to live this life. And that's the choice I made, to live my truth. I did not choose to be trans. I feel like my transness was innately in me. And so I don't want somebody who detransitioned to go and do all kind of crazy stuff because you and talk shit about trans people because you made a wrong decision. I've been steadfast in my decision for 25 years now, almost about to be 30 years now. Like, there's nothing that's the best decision of my life. And so don't get out here talking crazy about the rest of us. Get off the boat, but don't try to sink us. You don't have any empathy for you was over here at one point. You needed resources and care as one of us at one point. Why would you want to sink our boat just because you made the wrong decision? That's how I feel about detransitioning. I'm okay with it because that's their life. And sometimes people have to do what they got to do to had to do what they got to do in order to, be happy. And sometimes you go down a dead end. We do that in romance. Sometimes you got to, oh my God, he was so cute. Oh my God, he treated me so good. I saw all the red flags, but I ignored it. Sometimes with romance, we go down the wrong road and got to turn our ass back around and be single again. After 5 years in a relationship, after 3 years in a relationship, sometimes you just got to go through shit. And then sometimes it's the whole transition was a mistake. That don't mean the rest of us was mistakes. So I wanted to kind of make that clear. And that video, I'll post it again, is about me talking about my ideas around detransitioning. And so what they're doing in this case is making it seem like, they want to emphasize the detransitioner, even though it's a small percentage. And if you want to detransition, stop. But no, you every surgery or every path has consequences.
Having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that category that distinguishes on that ground is not a suspect classification? I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
It's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB1, this is a law that I think is easiest to understand and the most straightforward classification on the basis of sex.
So, Mayor?
Yeah. So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is
Justice Sotomayor.
Sixth Circuit conclusion that rational basis review applied, correct?
That's correct. Yeah.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children.
Yes.
Which would present a very different than Arlington Heights perhaps question, but the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kagan?
Two basic questions. So whether we apply a rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it. It's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me. But it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed.
No.
And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay, so if I could just make a few points in reaction.
I had one more point,
okay.
to add to that. And I don't think, with respect, that what you and the Solicitor General said, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have the same discussion as I see it. So just to get you thinking about that too. Go ahead. How about it?
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that, with respect to the difference between rational basis and heightened scrutiny, yes, of course, it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny. And we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient?
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to there are risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible, because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Tragale, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service,
Yes.
but I didn't
This
know
is
about
Amy
the
Coney Barrett, but the one
statutes
before.
prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life. And there's a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Justice Jackson?
So I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening? What is the justification? And then you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that. And the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine, is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
We are.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Period. All right, so we see what just happened there. Ketanji Brown Jackson jumps in to guide the conversation. She says, look, I'm a little bit worried because we keep talking about this shit in a certain way, but I thought, since I am a judge and been doing this thing for all my life, qualified, I thought that this was the bedrock. This was core foundational constitutional protection. And it's getting me kind of worried because if we get to shaking this shit up, Loving can be overturned. Griswold can be overturned. And we already done talked about it. We told y'all before this election that they are trying to overturn stuff, and y'all let them play in y'all face. And during that Trump first year, she's not saying all this, but this is the implication. This is the subtext. Y'all let them play in y'all face, and because y'all hired this fucking orange guy, and he done put all these conservative judges on the court, and they overturned Roe. They already, this is what's also insane for me. They're giving you the game plan. Like, they literally are giving you the game plan. They're giving you a book. They're giving you their playbook. Like, Project 25 is their playbook that they've been working on since the 70s. And they're telling you what they're trying to do. They're telling you. Thank you, Wade. The fact that they are associating cross-dressing with trans women is a problem within itself. Not really, in the sense of why the laws were made. They're not really. I understand what you're saying on a like an old school level, but those laws, like Chase said, like there's incidents where laws would lump all of us in together back in the day, whether you're a butch queen dressing up in girls' clothes or a trans woman dressing up in girls' clothes, it still is criminal. It was still masquerade laws that we all, regardless of our identity, would get in trouble for. And so what she was asking was there laws that kind of demonstrate that, and Chase was like, yeah, cross-dressing is the most. There's tons of other laws, but the ones that I know are super appropriate for this answer is the cross-dressing laws. And what else did he say? cross-dressing laws, and there was something else. There was something else that he said. I can't remember. I want to go back, but something else. Cross-dressing is something else. What was he saying? Anyway, with somebody, military bands. Thank you, Java. And the military bands, because that's specific to us, that don't have nothing to do with necessarily where it lumps us all in. Don't Ask, Don't Tell was about trans and gays. You see what I'm saying? So for that particular answer, yes, in general conversation, we want to make sure that we're not lumping trans women into the conversation of cross-dressing. Yes, absolutely. You're totally right in that instance. But when it comes to the answer of the question and asking the question so it can be clear, that's the reason why it was asked. One of the reasons why it was asked, even though it was Amy Coney Barrett asking it in a way to still steer it in that direction of, is this really for us to do? They're trying to avoid making the decision. These men who are cross-dressing just to go into the women's restrooms are perverts and not real trans women. But there's really not that. There's not a lot of that going on. That's another element. You cannot believe that is going on. Listen, there's some people who are doing it just because it is the topic of the day now, just to do it, just to be funny. But in general, prior to this spotlight being on trans, there wasn't men dressing up to go to the bathroom to harm women. That just wasn't happening. There was very few cases where that was happening. And when I say very few, I think that there was like one, and it wasn't in the case of them dressing up. He was putting cameras in the fucking bathroom and going in there and watching. So there was really no trans, and they weren't trans. They didn't identify as being trans. So yes. So that really wasn't happening in the way that was a not a ruse, but it just was fake. It was a scare tactic.
Mr. Rice? Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions.
So this is
an across-the-board rule that allows the use of drugs.
I lost track of the discussion you were having about COVID. What was the point you were trying to...
And who are we as the court to say otherwise? I'm worried that... So setting aside that other...
Okay, hold on. I gotta go back. I pressed the button.
I get it if there was no medical purpose. Reality or to...
So now that we've heard that our side of lawyers, now we're about to hear, they didn't switch. We're about to hear Tennessee's side of the lawyers.
In any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening? What is the justification? And then you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be.
I don't know if this is before or after. I don't know if I went back too far or went back too far.
In a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or what the state is, why the state is saying.
We already will listen to this, but it's coming up. So the Tennessee people are about to The people who are not on our side are about to be questioned by the judges.
And I guess my real concern, and maybe I'll just ask you to react to my loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw class lies, I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Now, this is the people who are against us.
Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policymaking. As Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, counselor. Every medical treatment has a risk, even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other, one person of one sex from another sex, from receiving that benefit? So if the medical condition is unwanted hair by a 9-year-old boy, who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age can get that drug, but the other can't. That's the sex-based difference. It's not the medical condition is the same.
We don't
but
agree.
You're saying one sex is getting it and the other's not.
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it to a minor who wants to transition. Those are not the same medical treatment. And once
what
you
you're saying is
recognize,
you're still depending on sex to identify who can get it and who can't.
I don't think so, Your Honor. If a minor comes up to a boy, he goes to the doctor and says, I want puberty blockers to transition, the answer will be no. If a girl goes up to the doctor and says, I want...
If a sex-neutral looking child walks into a doctor and says, I don't want to grow breasts, doesn't the doctor have to know whether it's a girl or a boy before they prescribe the drug?
I don't think so, Your Honor.
I got to tell you, I've made that mistake on children often. Look at one of them and think it's a boy, and I'm corrected, and it's a girl, and vice versa. I hope that you're not going to tell me you haven't made that mistake.
Well, I may have made that mistake, Your Honor, but I don't think that is an example of where a sex-based line is being drawn.
Why not?
Because
please.
Because all that matters is the medical purpose for which the drug is used. So if the minor comes up, if you have a biological...
No, it's the same medical purpose. Her hypothetical is, I don't want to grow breasts. Same medical purpose. I'm trying to stop the development of breasts.
Well, Your Honor, I think that likely would not be allowed under SB1 for a girl.
For a woman who is, for a girl. But
it would also not be allowed under Tennessee law with respect to a biological boy.
Really?
Tennessee law doesn't just allow doctors to prescribe drugs without a medical purpose. They can't.
No. But the way I understood the law to work is it has to be inconsistent with your sex in order for it to be blocked. So I don't understand why a boy, I don't understand why it would work in the way that you're saying. Why wouldn't it be differentiating on the basis of gender? A girl who doesn't want to grow breasts for whatever reason could or could not get it.
Does not want to grow breasts without a medical reason, could not get it.
And a boy who doesn't want to grow breasts could or could not get it.
Could not get it if there was no medical purpose. There has to be a medical purpose for these drugs. All my friend's arguments rest on conflating different medical purposes.
But they couldn't get it not under this law, right? Because this law is operating around the inconsistency. So if they couldn't get it, it would be for some other reason, right?
But we have other laws in Tennessee law that prevent malpractice and that prevent the use of drugs for a non-medical
I understand,
purpose.
But this law is the one that is being challenged today, and we're trying to decide whether or not it's operating on a sex-based basis. And
I don't think
we have so what about my lower voice hypothetical?
Yeah.
All right. So a biological boy comes in and asks for a hormone treatment to deepen his voice in order to affirm his masculinity because it hasn't come and he'd like to deepen his voice. Can he get it?
If there's no medical purpose, no.
No, that's the medical purpose. I don't understand what you mean. The purpose is to bring on a deepening of their voice.
Let me try to rephrase.
Yes.
If there's no medical condition, the answer is no. You cannot use testosterone for purely cosmetic reasons. It's a Schedule III drug.
In this statute or in another statute?
In another statute.
Okay, so setting aside that other statute, we're looking at this one and how it operates. This statute says something about inconsistency with your biological sex, and that's what I'm trying to test. The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? Under this statute?
Under this statute, no, but under Tennessee Code annotated 63.
The boy could not, under this statute, to get a medication that would deepen his voice?
If there was no medical condition, no.
That's the other statute. Under this statute, With respect
Under
to
this statute.
consistency, he could.
Under this statute, he could. Under 63-6-214-12, he could not.
I understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone to deepen her voice in order to affirm the identity that she chooses, which is masculinity. I'm asking you, would under this statute, she be precluded from getting that treatment?
She wants to, I'm sorry, one more time, Your Honor.
She wants to get the medication in order to deepen her voice and affirm her masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be barred from doing that under the.
But isn't that the point, Mr. Rice, that if it's for the purpose of identifying with their sex, I mean, the prohibited purpose here is treating gender dysphoria, which is to say that the prohibited purpose is something about whether or not one is identifying with one's own sex or another sex. The whole thing is imbued with sex. I mean, it's based on sex. You might have reasons for thinking that it's an appropriate regulation, and those reasons should be tested and respect given to them. But it's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
Justice Kagan, we think that is a slightly, we think that's a request for a substantive right to engage in non-conforming behavior. We don't think it's actually drawing a line based on sex. And again, the only way that my friends can point to a sex-based line is to conflate the use of puberty blockers to address precocious puberty with the use of puberty blockers to transition. And those are fundamentally different treatments. They have different effects on the body. They're used for different purposes. I actually think my friend's response to Justice Alito's hypothetical regarding puberty blockers is devastating, because that law draws no different lines than the law that's drawn in SB 1. It just doesn't use the words inconsistent with sex. So we use the words inconsistent with sex to describe a single prohibited medical purpose. We do not use it to draw lines between males and females. Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult the science may be, and no matter how evolving it may be, at the end of the day, legislation on this subject is subject to judicial review. Yes, sure. Correct? And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of the scrutiny that's applied? Yes, Your Honor. Okay, thank you.
Counselor, given your argument, you're saying your state can block gender treatment for adults too.
Your Honor, we think that if we're assuming a similarly worded statute, that there still would not be a sex or a transgender-based classification.
So you're licensing states to deprive grown adults of the choice of which sex to adopt.
Your Honor, I don't think that's a fair characterization.
That's what you're telling me, because you're saying to me rational basis would be the review for that kind of law for adults as well.
And this court has not hesitated to hold laws unconstitutional under rational basis review when they are rooted in unsubstantiated fears and prejudices. That's exactly what this court did in Cleburne. And
that's
to the extent,
quite an interesting way to protect the population.
And to the extent, Your Honor,
I thought that that's why we had intermediate scrutiny when there are differences based on sex, to ensure that states were not acting on the basis of prejudice.
Well, Your Honor, of course, our position is that there is no sex-based classification, but to finish the answer, that to the extent that a law with dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
So when
you're 1% of the population, when you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
Mr. Rice, I have one factual question, then one legal question. The factual question is, the Sixth Circuit mentioned that this is an off-label use that the FDA has not authorized. Is that still true? And is that just for children or is it for adults too?
It's still true. I think with respect to both children and adults, I know with respect to children, I'm not certain with respect to adults, but we do think that that's relevant in the sense that the FDA, when it approves drugs, it does so based off of the purpose for which the drugs are being used. And we think that we are drawing the same type of distinction in our law between using one drug for different purposes.
Okay, my legal question is, I wondered if you had a response. You know, I was asking your friends on the other side about de jure discrimination and what we should take account of if we're thinking about whether transgender people should be a suspect class for purposes of the 14th Amendment. Do you have a response to that? What we should be thinking about, or whether do you know the history of de jure discrimination?
I do not know the history of de jure discrimination. I mean, our frontline position is that the court has gotten out of the business of creating new quasi-suspect classes, precisely because it's a very unprincipled test when it comes to creating these.
No,
classes.
I didn't. I went to the store.
In some of the cases, political powerlessness means that you need protection from the majoritarian process. In other cases, it means can you gain the attention of lawmakers in the most recent Cleburne test? So the court has not applied any form of principled analysis when it comes to creating these tests. It's been an exercise of judicial power. And the intermediate scrutiny analysis that accompanies the quasi-suspect classification is no more principled, and the court has often struggled to apply that as well. So we don't think the court should even open the door for further judicial creation of new quasi-suspect classes.
Okay, and last legal question. I was just going to ask you one. I have a second one. Could you address Justice Kavanaugh's questions about what the implications of this case would be for the athletic context or the bathrooms context?
I would love to, Your Honor. So we think this is, we differ with our friends on the other side with respect to their argument is that, well, there's a sex-based classification in sex-separated sports. So necessarily that means that there's a sex classification, intermediate scrutiny applies. We are not actually seeing challenges to the sex classification. When these challenges are being brought, they're not arguing that we don't want there to be boys and girls sports. They're arguing we want there to be boys and girls sports. We just want to be classified based off of our gender identity. And so we think that is a fundamentally a transgender-based challenge and not a sex-based challenge if you are not actually challenging the sex classification that is at issue.
Can I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been making a racial classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Yeah, we think that in a case like Loving, when you look at the individual level, which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level, that if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race. You couldn't if you couldn't. I take your law to be doing basically the same thing. You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So how are they different?
We think it's different because we think in their use of inconsistent with sex and all of these examples that they have in the briefing, those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, The only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not only
what's your basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds.
Oh, I'm sorry. I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to
because that's what he said.
Example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
Can I ask you about one of the purposes of this law? And I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization.
Well,
of our
encourage
law.
minors to appreciate their sex.
I want y'all to see what he look like.
Treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls.
If I could,
and that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
If I could make a few points. First of all, it sounds like the question is rooted in a potential improper
Matt Rice, you ugly
argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely, and I would love to address.
And what seems to have produced this classification is that we want to ban children treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So,
but that's what the fuck you saying?
Reference in detailed and legislative findings. That is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that has to be viewed in the context of the legislative findings, with which both emphasize the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research and that assessment of whether the findings
because it's
of
bullshit.
Study, but the legislature specifically,
and then don't negate all the tons and millions of other people who don't experience that.
This is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.
Go ahead.
You go.
No, go ahead. No, go ahead. I'll be back. Justice Kavanaugh.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state, particularly in a situation, as General Prelager said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports.
Yes, Your Honor. So, as my friends recognize, the parental rights question is not before this court.
It's a good question, though, Brett.
Explained how it informs. So just take the question as best you can.
Yeah, I think our position is that there are certain times in medicine, history has shown where the states in their traditional role as regulators have had to intervene. And that's not because, of course, the parents are trying to do the best they can and get the best treatment for their kids. But we've had multiple instances in somewhat recent history where we have stuff like lobotomy, eugenics, that had widespread acceptance among the medical community, and the state had to intervene as a regulator to protect the children.
Lobotomy.
Mr. Rice, just to let you kind of finish what you started to say to Justice Kavanaugh, you agree that the parental rights question is not before the court, so it would be open to parents to continue to press that point in other cases.
We agree, and we think Chief Judge Sutton got it right, but we agree.
Can I just ask you about, I don't understand at all the similarly situated argument that you make, and I hope that you can help me, because I don't know how you can say both that girls and boys are not similarly situated at step one when this law is being evaluated and it's not making a sex-based classification. It seems to me that recognizing their lack of similarity, as you do in making the argument.
They weren't laughing at him. They was laughing at the judges.
So,
I think our position is that if you're in the point where we're treating giving testosterone to a boy with a biological deficiency as the same thing as giving testosterone to a healthy biological girl who wants to transition, then there has to be some threshold inquiry that recognizes the biological differences between those two.
Right, but when you're doing that, you're making a sex-based classification. I mean, the very argument carries with it the characterization that we're trying to identify here. You start by saying it's different to treat a boy who's using this medication for a particular reason from a girl who's okay. So that's a sex-based classification, haven't we?
Motherfucker, duh.
Should be going on to step two. Intermediate scrutiny applies by the terms of what you're arguing.
I don't think that we agree that we've checked the box at step one, because there is no medical treatment that boys can receive that girls cannot. So we disagree with the notion.
Didn't we already dispose of that kind of reasoning with our equal protection cases that looked at things like interracial marriage, where we said, even though it applies to both, it's still making a racial classification? Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged. We said that's not an argument for why you shouldn't have a heightened scrutiny or why the statute is not making a race-based classification.
And that's not the argument that we're making.
Okay, so
we are not arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and
you sound stupid.
You can get the puberty blockers if you're going to use them for precocious puberty. You cannot get the puberty blockers if you're going to use them to transition. That is not a sex-based line. That is a purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here. And the only way to get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.
And the treatments are different because of the biological sex of the person, right? I mean, that's what you said. The purposes are different because of the biological sex and why you're going in to get them.
Not at all. I mean, with puberty blockers, the purpose, nothing turns on sex. Take puberty blockers. There's nothing that turns on sex. as to whether there's a sex-based classification there. Everything depends on what is the reason that you are using those puberty blockers for.
But that's based on sex. Clown.
I'm happy to take more questions if the court has them.
Justice Thomas?
A number of times you've mentioned off-label uses of these hormones. What are some of the other off-label uses that are not legal in Tennessee?
So, for example, Your Honor, testosterone, we have a separate law that prohibits the use of testosterone for hormonal manipulation intended to increase muscle mass, strength, or weight without medical necessity. We have, like every state, we regulate medicine and we regulate the use of drugs. You cannot use drugs in the state of Tennessee if it's not for a legitimate, viable medical purpose. Here, through this law, all that we have done is make clear that
trans
which are irreversible,
people
often have significant effects.
Treating their
on
gender
minors,
dysphoria
and
is
often
a
leaves
medical
them with
issue.
bodies that are infertile and permanently
Like, that's already been
damaged,
established.
that you have to wait until you turn 18 to receive those type of treatments.
A number of times you've tried to say that what the classification that the state of Tennessee has advanced in this legislation. Would you spend a few minutes on that?
Yes, Your Honor. So again, we think that our law fundamentally draws a distinction based on medical purpose. I'll go back to puberty blockers. If a boy wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. If a girl wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. That is fundamentally a different treatment, and what is dictating under this law is the use for which you are putting the drug. And just to kind of build out on the notion that these are not the same treatments, we talked about earlier testosterone. If you give it to a biological boy, it allows the boy to develop a normal body and healthy body, whereas providing it to a girl causes a physical condition, hyperandrogenism, and that results in clitoromegaly, atrophy of the lining of the uterus, blood cell disorders, increased risk of heart attack. So the notion that the risks are the same when you give testosterone to a boy as when you give it to a girl are simply not borne out by medical reality.
Justice Alito? Justice Sotomayor? Justice Kagan? Justice Kavanaugh?
Just one clarification. It's an obvious point, but I want to make sure you agree with it, which is you are not arguing that the Constitution takes sides on this question. You, as I understand it, you are arguing that each state can make its own choice on this question. So from your perspective,
That's what they're going to do.
as I understand it, it's perfectly fine for a state to make a different choice, as many states have, than Tennessee did, and to allow these treatments, correct?
Yes, Your Honor, that's correct. And we think that's because of what Your Honor has pointed out, that no matter how you draw these lines.
Thumbs up if
there
you're
are
here
risks
watching and you haven't
potential
thumbs up.
benefits and harms to people on both sides. And the question of how to balance those harms is not a question for the judiciary, it's a question for the legislature.
Thank you.
Can states make a different choice if doing so means that a state's law operates to treat its citizens differently on the basis of name the suspect classification? I thought that was the work of the Constitution and the Equal Protection Clause.
Your Honor, we don't think that it draws any lines based off any.
No, I understand. I'm not talking about this law. I'm going back to Justice Kavanaugh's suggestion that the Constitution doesn't play a role if the state is making a policy choice regarding issues such as these. And I guess I'm still seeing a role for the Constitution in circumstances in which the claim that is being made is that the state's choices are implicating the equal protection rights of its citizens.
I think the point, I don't want to misstate the point, but I think the point is that the Constitution is neutral in the sense that it does not provide heightened protection based on any suspect classification, and thus rational basis review applies in the presumption of legislative validity and the presumption that these types of policy choices are best left to the democratic process. I think that is exactly what the correct way to think about this case.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you, Mr. Chief Justice. 2 quick clarifying points. I want to make clear that Tennessee here is not regulating based on off-label use. Off-label use is extremely common in pediatrics, and we've pointed to a number of uses of these medications on page 40 of our brief.
Come on, Elizabeth.
Medications that likewise are off-label use. If there are problems with safety and effectiveness, then that would not become the standard of care, and there are self-regulatory measures to address that issue. Justice Kavanaugh, you said this might be a space where each state can make its own choice, but I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress. And so I think that the court should keep that in mind when thinking about the level of scrutiny here. There were a lot of questions about how to take account of disputed medical evidence when there might be some uncertainty. And I want to make a few points. As my friend acknowledged, that doesn't go to the level of scrutiny. So that doesn't mean that you should ignore a sex classification when one exists in the statute. But at the point of applying heightened scrutiny, the court can take context into account. And we're not asking courts to step in here and say, we want to figure out as a matter of policy exactly what the right approach is. But you can ask the familiar judicial questions like, does the state actually have any evidence to support its claims that there's a harm to adolescent health? And is this law severely over and under inclusive? And if the court conducts the analysis here in the first instance, this law doesn't look anything like a typical medical regulation to protect adolescent health. That would look like the West Virginia law, where you're tailoring it, but still leaving some possibility for care when it can have enormous benefits. And the reason it doesn't look like a typical medical regulation is because the legislature was doing something different in trying to get minors to appreciate their sex and not become disdainful. That's not a medical-based justification, but I think it shows exactly why the state drew the lines where it did. Finally, I think the court should think about the real-world consequences of laws like SB 1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care. And they say this is about protecting adolescent health, but this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health. But the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
Bam. So there we go. Any last thoughts? The court is adjourned. We will get the tea on Monday. We will get the tea. So what I think they're going to do is, because we have a stacked court of conservative people, conservative judges, I think that they are going to say that this got to go back down to the states, which is going to harm people in states that don't have trans protections. States that do is going to be like New York City, New York State, California, New Mexico, I think Wisconsin, I think, Massachusetts, states with protections. Oh, Monday, I thought we were getting a decision in June. I don't know. I don't think we get it on Monday. Or maybe I'm tripping. No, we get it on Monday. It don't take them 6 months to decide. Thank you for listening, Java. I'm glad Elizabeth is back. No shade to Chase, but Elizabeth is great. I think they both was great. I think they both was on point. Colorado, you are protected. Colorado, yeah. You will get it springtime. Okay. Was it spring? Yeah, I don't think it's June. Wait. All the way till Monday? Wait till all the way till Monday? I mean, all the way to spring? I thought we'd get it on Monday. Maybe I'm tripping. But yeah, but anyway, whenever we get it, we have listened to the case. We have listened to what the people is giving. Part of me is excited. Yes. Part of me is so it's almost like, I don't want to say like a video game to trivialize it. But it's like, when you got to go on a trial. I don't know if y'all play RPGs, but say that you like a multiplayer trial, and like you excited about the battle that you're about to do with your people, with your group, with your team, because you're excited about this new expansion pack. You're trying to beat it and get to the next level, get the next armor, get the next, dominate this new expansion. That's kind of what I feel like. We're on the precipice of a new expansion. Like we're in the thick of the battle. In this, when I was younger, like in the 80s and the 90s, we talked about, and probably early 2000s, we talked about the civil rights movement in a way that was very disconnected, like it was far away, old timey days, and it was a battle. And it almost like, you just speaking of the theory, we have fought the battle. They were the soldiers in the battle. You get what I'm saying? Even when we think about like the Civil War, and then when we think about the civil rights movement of the time of the 60s, it almost was, even though in my time of growing up, we were going through a battle when it comes to gay stuff, when it comes to AIDS, and the stigma of HIV and the stigma of being gay and all that kind of stuff. Even though we were going through that particular battle, when you're in it, sometimes you don't feel you. When I was younger, I didn't feel like I was in the battle because I was too busy navigating the stuff that was going on with my mom's addiction and homelessness, and just so much stuff, and growing up as a kid and coming into my identity as a teenager. And so I didn't really have time to sit and think of myself as a person doing something about it in a way that's active and in a way that's really in the news and thinking about what's happening on the legislative level. I didn't think about that in the 90s. I was just fucking living my life trying to be a girl. So now that I'm older and we're going through this time now, It feels like, oh, this is where you earn your stripes. This is where you earn your legacy. This is where you earn. And some people don't care about that. I was on a phone call with one of my listeners that she's been listening to me. I talked about it yesterday about she was listening to me since she was like 15 and now she's in her 30s. And she said, one of the things she says, Diamond, I can't be you. I'm not that she was trying to be me, but she says, I don't give a fuck about community. I don't want to be an activist. I don't want to do none of that shit that you be doing or any of that. I want to just be a woman and be in love with my man and cook and clean and be a woman and da 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 da. I don't give a fuck about no damn community. I don't want to be an activist. And there are many people that are like that. I think there's many people who are like that. That don't want to be an activist. And so, yeah, I'm the total opposite. I find I don't want to be an activist in a sense of where I don't want to enjoy life. I don't want it to be all that I do. But I think that as a human, you should have an impact on um you just being here is going to have an impact on somebody. So, yeah, you're going to have a legacy. I just feel like I find it important for my legacy to be as big as I can comfortably make it. And so, comfortably, meaning that I'm not sacrificing my whole fucking life on activism or uh, fighting transphobia. No, I want some joy too. So I'm going to be following my dreams in other kind of ways. And my dreams is me traveling the world and going to different places and learning about culture. I love that as my personal dream in regards to just life. I love experiencing life. And so, but my legacy work is about doing what is comfortable in fighting against transphobia, in fighting against racism, in fighting against white supremacy, and fighting against these things. So because of I intentionally do actions that fight against those systems, it does make me an activist. And I'm okay with that title. I'm okay with being that. And so this feels like one of them times where you know how people always talk about, ooh, I'm not my ancestors, but they ain't really doing nothing but going along with the status quo. Like there's some ancestors who were like, oh, I'm bucking up against the system. And then there was ancestors who, and not saying that either one of these are necessarily a bad thing, but there are some ancestors who was like, yeah, I'm just gonna follow the rules just so I can live. We need people like that, because if everybody was a Nat Turner, everybody would be a Nat Turner and be dead. Do you see what I'm saying? There's some people who the strategy is to just survive. And I don't think that that's a bad thing. I just don't want to be that in a sense of I don't want to be that passive. I don't want to die, but I don't want to be that passive. I'm willing to take a little bit of risk. I'm not just getting on to get on. I don't want to be the person that just, I'm just coming in and out. I don't want to cause no trouble. I just want to I just want to live. I just want to be happy and da-da-da. I don't want to be that. I want to do whatever I can to buck up with the system. I can't say that I'm about to go and put myself in front of a gun for nobody. I don't want to say I'm about that life in that way, but yeah, I might go to a protest. I do it every year. I go to rally at the state capitol. I go to you get what I'm saying? I just put myself out there and in an exposure in a way. You know, 2 years ago, not 2 years ago, a year ago, I got my first. Well, no, it's almost been 2 years ago. Yeah, it's been about 2 years ago. I got my first direct to my house death threat. I had never have I got people sending me emails talking about you never being a woman. You'll never be a woman. Oh, you're just another faggot with tits, or whatever kind of transphobic shit that they want to email me just to be a troll. Have I got that? Sure. But 2 years ago, I got my first directly to my house death threat. That had never happened to me before. So that indicated to me that as long as I've been out here doing my thing, the tension anti-transness is specifically heightened in a way that it has not been for most of my life. Or it was heightened in another way. No, it can't compare to any other time in my life. And I am visible in a way that I had never been in any time in my life. Prior to 12 years ago, most of my life is most of my life has been trying to be stealth to some extent. Um and enjoying the luxury of passing so I can just be free. That has been most of my life. It hasn't been until the past 15 to 12 years that I've been pretty visible. I mean, with the rate of trans violence, we all are instance of putting ourselves in a line just for leaving the house. There's a level to that. That's true. Yeah. I feel the same way about not wanting to be passive. I just want to find my brand of activism where I'll be the most effective and helpful. Yeah, I think that's what it is. I think figuring that out, I just don't want to be. I don't. Basically, what my friend said she was, I don't want to be what she was. She was like, she specifically said, "F the community," and I think that's just about my politics. I am somebody who feels like you have to have a certain level of self-love, but I think and I don't think this, I know this because this is data driven. This isn't just me thinking it, just a theory. This is data driven. People survive life because when they have a core support system of community, when they have a sense of belonging, when they have a sense of support and a sense of purpose, when they have these things, a sense of belonging, it drastically improves the quality of their life. So people who are isolated and who don't have people, and we're not talking about, oh my God, I have to have a million different people in my community. No, I'm talking about core people like one friend, two friend, three friend, like just, it can be a small group, but that is your community. That drastically every kind of indication of negativity that can happen when it comes to depression, suicidal ideation, um, poverty, homelessness, da, 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 da. When you have a support system of a community of people, all those statistics go down in regard to your chances of being affected by those things. It don't mean having community stops all problems from coming. Absolutely not. But it does give you a support system to navigate through them. And so with people who usually have the mindset of fuck community, they don't build relationships with people, authentic relationships with people. And so when they're going through problems, they don't have a support system to help them go through it. So that makes them more vulnerable to not to wanting to kill themselves, make them more vulnerable to depression, which spirals down to losing a job, losing housing, da 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 da. All that kind of stuff leads to that. So people who say fuck community, it's usually people who need a fucking therapist. They did, which what could be what could be a part of your community. Um, but yeah, I never want to be that person. There's many times that community has changed my life, saved my life, um, saved me from being in harm's way. And so there's a certain level of care. Um, there's a certain level of I've never felt alone in the world. This is unusual, but my friend at 11, 12 was a trans woman. And she, as you can see, she's in the chat. She's still my friend. She lives fucking six streets away from me. And we grew up in the same city. Most people don't have that. That's my longest queer friend. Most people don't have that. And so I can say that I grew up and was able to go through my transition with somebody who was going through the same thing. Most people can't say that. That's a community anchor that I can have. Um It was a time when I was homeless and a trans woman let me sleep on her couch when I didn't have anywhere to go. When I couldn't stay at the women's shelter, I couldn't stay at the men's shelter. All the safety nets for somebody cisgender that they can use, I could not because I was a trans woman. And there was a trans woman who let me sleep on her couch when I didn't have nowhere to go. Who knows what I would have had to do? What risk I would have had to take? You feel what I'm saying? So there's been too many times for me to be like, fuck community. There's too many times that community has helped me or benefited me in some kind of way. And this don't mean that I have some romanticized view of community. Like there's not toxic people in it or toxic people that I gotta avoid or that I gotta block, that I gotta not be around. Yes, community got just like any other community. It has some bad apples. It has some bad people. It has some traumatized people. They're not necessarily bad, but they're traumatized. And so how they engage with you y'all might can't engage. They might can't engage with somebody else, but with you, somehow your trauma, their trauma just don't mix. So y'all can't be friends. Y'all can't work together. Y'all can't be in close community. There are tons of people like that in this community. There are tons of people in my community that I'm like, I'm in community with you in regards to our identity, but I am not going to ever be close to you because you have not worked through your traumas or you are just not a good person. And so I can't be in community with you. How you think about things or how you move in the world is toxic to me. So I can't be in your community. So yes, there's no romanticized mindset about community for me where I think it's just this purple gumdrops and rainbows. No, but I do know the power of having a core circle of people who you consider your community that you can hold on to and that can be a part of whatever your solace and whatever you need in regards to surviving when life comes up. It's hard to find real friends like that. Trans women letting you crash there. She wasn't a real friend. I don't want to say that, and it wasn't because she didn't benefit from it. She benefited from it. It wasn't like, oh my God, out of the kindness of her heart. She didn't have to do it, but it wasn't solely because, oh, I'm just being a good person. No, it wasn't that. But I still can't throw it away. It helped me. It was a stepping stone for me to get somewhere else, regardless of her intentions. It still was a stepping stone for me to get in a better position that I utilized, and it changed it changed my scenario. Her reason was to use me to get I don't know. Did it just cut off? Are we back? It just randomly cut off. Are we back? Or no? Can y'all hear me? Oh, we're back? Okay. I don't know what that tea was. But yes, it is one of those things that yeah, it just totally crashed for me. And I had to reconnect. Anyway, so what was I talking about? Yeah, it wasn't out of kindness or heart, but it benefited me. And so I can't throw it away. Like even, she was trying to she wanted to use me for my connection to get her body done. But I don't, fair exchange ain't a robbery, honey. If you want something from me and do something for me, it's still a good thing. If you do something positive for me and I can trade it for something I got for you, I don't think that's not robbery. I don't think that's shady either. I think, relationships should be reciprocal. Now they should be honest. We should know the terms. Everybody should know the terms. So if you're hiding that fact, those terms, then it can be kind of shady. But I benefited it. So I benefited from it. And so I don't think that's negative. But anyway, my point is I like being in this scenario where I'm alive and now we are fighting for something that could change the life for trans people in the future. I like the idea that how we talk about Fannie Lou Hamer, Ella Baker, Martin Luther King, Bayard Rustin, all the people who were active, how we talk about them in the 60s. I hope that however I leave this earth, that somebody might talk about me in that way. In all the projects that I've done, all the stuff that I've been a part of. I'm the first Black trans Harris County commissioner in Houston, Texas. Black trans woman, Harris County commissioner. I'm the first one. So regardless of if I die tomorrow, that's something that's gonna go be in the Houston history books. I'm coming up on the 19th will be my 1 year anniversary. So you get what I'm saying? I that's how I want to be. Those are the type of things that I want to be a part of. Those are the type I want. You know how if you see those sometimes I'll run across old pictures in moments of like the civil rights movement, and I'm like, oh, look at all these people in that group. Ooh, here's a picture of the women's league, and this is oh, that's Polly Murray right there. She was in that picture and didn't even know that she was going to be this iconic legal mind that changed the life of Americans. Because she had her impact hadn't been fulfilled yet because this was in 1940. You get what I'm saying? And so she's in this picture. And one day, somebody 60 years from now are going to see a picture of me somewhere. Oh, Diamond was there too? Oh, that's Diamond all the way there in the back. I'm tall. So I'm usually, you see these group pictures of people, I'm going to be in the back. And they're going to be like, oh, yeah, she was the, back there in the back, she was such and such, such and such. Oh, and that's Diamond Style. She was a Harris County commissioner. And I I love that. I love that that's a part of not being forgotten. I don't want a life that's going to be forgotten. I just don't. Um, when somebody talk about me being young in Indiana, they're gonna have to talk about me suing my fucking high school and being the first person to set that precedent. Suing they asked to go to the prom in a gown, directly connected to my transness. That can't be erased. Regardless of what happens, that can't be erased. I'm the first open trans woman to go to Jackson State University. Whether people care about it or not, it happened. And so when some queer person at Jackson State talks about the history of people going there, the LGBT history of that school, you can't erase me out of that conversation. If you're accurately documenting the conversation, and that's important to me. That's important to my life as a human being. I want to be remembered. I was here. That Beyonce, I was here. That's almost one of my favorite Beyonce songs. I was here. You're gonna know I was here. Wherever I tried to make an impact, wherever I was. When I was in Indiana, a red state, made an impact. When I was in Mississippi, a red state, I made an impact. When I'm in Houston, made an impact. If I move somewhere else, I'm going to get involved and try to make an impact. That is what I do. That is a part of me, a part of my brand, a part of who I am, a part of my politics, a part of my integrity, a part of what I care about. That's what I do. Yeah. I connect myself with people and whatever resources that I have, I try to impact their legacy too. Like, I have friends that are out here doing amazing shit. Like, amazing shit. And any coins I get, I'm going to try to throw it to them so they can honey, you trying to go to such and such to get this? I'm gonna try to do whatever. I'm gonna get your bus ticket or get your air back in the day. But now I'm gonna get you a plane ticket so you can make sure you go. So it's not just me. It's people that I care about. It's my community. I want the ones that care about being that impactful. I want to support them being impactful too. I wish I could be like that, but I got to get over my submissive tendency. I don't think it's a life for everybody. I don't think everybody has the but I think it's levels too, because there's certain things that other people do that it just couldn't be me. It reminds me of Toni Morrison. Remember, Toni Morrison was like, I'm not the bitch. She didn't say this, but she didn't say that. But in other words, she says, I'm not the bitch that's gonna be out there in the street marching and doing all that shit. That ain't me. Yelling and screaming in the police face. We want our rights. That isn't me. You know who I am? I'm a Random House editor. That's my position in work. So you know what I'm gonna do? I'm gonna go find all those activists that's going up against the laws, like um like Angela Davis. She was on the FBI list. I'm gonna go get Muhammad Ali and make him write an autobiography. I'm gonna capture the voices of these key players in community because that is the power that I have as an editor as the Black woman editor at Random House. I can actually, and this is what Toni Morrison did. That's why we get autobiography so early for Angela Davis, because Toni Morrison made that happen. And so she played her part. She did what's in her circle of power. It's not she knew I'm not a bitch about to be out here in you hoes. When we think about um Georgia, I'm gonna put her Georgia Gilmore. This is her story. Let me put it in the chat. Georgia Gilmore, the bus boycotts with her Southern cuisine. Oh, it's not giving me let me stop being a creep in my chat, honey. We're here to talk about serious stuff, not hot trannies. Calm down. Okay, we're gonna do this one because this one is kind of. All right, so Georgia Gilmore, when they did the Montgomery boycott, Georgia used her food to kind of pay for people's, like, she sold like plates. She was selling food and using the money to help people take care of gas. Her profits went back to the movement. While people wasn't riding the bus, she was using the money to help people, in carpools, et cetera, et cetera, et cetera. Like, she was secretly like feeding people and doing because they didn't understand how they was getting the money. And it was her. So that her name is Georgia Gilmore. And so that's what I'm talking about. She knew what she could do. She knew that she she knew that she I can cook. I know how to hustle. I know how to sell these fish plates. I know how to sell these oxtails. I know how to do this. So I can do something to contribute. Everybody ain't a soldier on the front lines of the fighting. Do we need those? Absolutely. But sometimes we need those nerdy girls that go into law and then become Ketanji Brown Jackson. Do you see what I'm saying? And sometimes we need those hood girls, those Banji hood girls that turn into a Glorilla, that turn into a Sister Soldier, that turns into to create a book like The Coldest Winter Ever. Do you see what I'm saying? Like everybody does their activism in a different way and contribute to the culture and the advancement of the culture and the humanizing of particular groups. Everybody does their own little their thing. And I think it doesn't have to be big. It could be small, but I think it's a part of for me, it's an important part of my legacy to be archived and to do groundbreaking work. Thank you, thank you, thank you. But all right, y'all, we've been on here for 5 hours discussing the Skrmetti case. I appreciate y'all. Yeah, make sure you are following it. I thought that they were gonna give a response in on Monday, but if we gotta wait till the spring, dang. But y'all know what it's about. Make sure y'all follow the case because it is one of the most important cases in regards to trans people that we have had so far. One of them now currently. So make sure you thumbs up. And I will talk to y'all tomorrow because tomorrow is Friday and that's my normal day to go live. I don't know what we're going to talk about, but I really want to talk about Lover Man, y'all. Let me give y'all this let me give y'all this let me give y'all this link. So this link right here is for y'all to bootleg. Now, I don't get no viruses from it, but I have Apple, so we really can't get Apple. We really can't get viruses like that. So I don't know if the sites give people viruses, but it don't give me nothing. I've been using it for some years now. But this show is called Mr. Loverman. It just came out in October, but it is from the UK and it's on their BBC One app. We don't have that here. It has the dude who plays on The Walking Dead as the lead actor. And this show to me, and y'all tell me when y'all watch it, this show to me is the best show that's about queerness, gay male, black queerness, particularly the down low topic that we have, or navigating black gay male identity, queer identity down low. This is one of the best ones that I have consumed since Moonlight. If I don't consider P Valley. Now, P Valley is that kind of nuance. They beautifully is blending that trans and queer male narrative because I'm not really for sure. Everybody is looking at Uncle Clifford. Is this a gay male? Is this a trans person? Is this non-binary? And anybody can look at that, the storyline of Uncle Clifford, which I think is beautiful, using a character like Uncle Clifford, using a character like Uncle Clifford is a plot tool that is kind of dope because it can relate to the trans story and it can relate to the high femme gay male story because we know those people exist in that nuance. Um, Even more than Noah's Ark. Noah's Ark came out years ago, so I'm talking about recent stuff. And I actually didn't watch Noah's Ark, but if I was to go in line, I would say Noah's Ark, Moonlight, P Valley. I didn't just go back that far. I know the impact of Noah's Ark, but I actually didn't watch it because when it came out, I was in my I'm a trans woman. That's Butch Queen stuff. So I never really watched Noah's Ark because I was in my and anti gay men stuff. Not against them, but that wasn't content for me. That was content for Butch Queens. That's what I was thinking when that came out, when Noah's Ark came out. I was trying to distance myself from queer men stuff. P Valley is directed by Patrick Ian Polk, who did Noah's Ark. Absolutely, it sure is. It is. It is. He does groundbreaking work. You know, I love that show. Me and Cliff needed logo. Yeah, logo was very that. But yes, I think that Mr. Loverman is the best storytelling of that centers queer gay men since I could say P Valley, but I would say Moonlight directly because P and Valley could be non-binary trans. But anyway, but even if you talk about Lil Murder being a down low man, anyway, it is the story of a down low husband and they're navigating him coming out to his wife after decades, and he's like in his 60s, 70s, or however. He gray hair, and how his children are navigating it, all this kind of stuff. It is so amazingly written, and they do flashbacks to why this happened, There's some sexuality nuances. It's just not him being a gay man. It's about other people are doing stuff that you like, what? And it makes you think about honesty and what is honest. Is this, it's so many layers to it. So I want to do a review on the show. I binged it all yesterday. I didn't even give it a chance to sit. I watched it all the way through, all 8 episodes, and it was so good. It was powerful. The acting was so good. I don't know what's the British versions of Oscars, whatever that is. I hope that they win it because it is good. It is so good. It is A+ to me. The acting is good, the writing is good, and yeah, it is so good. The sex scenes are realistic and not overly weird. It is so good. It is so good. It's so good. So good. So good. So good. So good. Yeah, it's so good. So check it out. And I put the link in the chat. I'll do it again just so that y'all can have access to it and it be free. Bootleg. So make sure y'all watch it if you want to discuss it. Take some notes. Tell me some things. Let's analyze it. Let's discuss it like we do. But all right. I love y'all. Have a wonderful day. Yeah, I've had an amazing week. This is my week of my mom's birthday. My mom's birthday is the 4th, and keeping busy and chatting with y'all and going out and just keeping busy has really allowed me not to dwell on my mother's passing. And it gets easier and easier every year. So I didn't shed any tears. It's one of the first years that I didn't shed any tears. It hasn't been overwhelmingly sad about my mom's passing. About my mom's birthday, her passing anniversary, luckily for me, is all at one time. So her birthday is on December the 4th, and her passing anniversary is on December the 18th. So it's all in 1 month. And so it used to be like, oh my God. Um, but but I like that because my memory of my mom, I use December as the memory of my mom, and I do stuff to kind of honor her in that regards. So it's been dope this year. It has been not as heavy and not as depression inducing, and so it's been really dope. And s- y'all have been a part of that, keeping me busy and um thinking positively. But all right, y'all. I will talk to y'all later. Be good. Bye bye.